All right, I'm back. Static beat me. Welcome back to the afternoon of day 9 of the Darrell Brooks trial. It's quite a morning. Blow up. He was removed from court. We'll see if he makes it through the afternoon without getting kicked out of court. I'm about 11 minutes behind the live now. We should make that up during the break and end live with the court. So let's jump straight back into it. From what I saw before as I was setting up the stream, because I had just left YouTube running, uh, it sounds like he's still objecting to everything. I think they were discussing the field trip to Main Street tomorrow, and he's objecting to that, or asking, do I have to go? I'm sure it'll be much easier if he doesn't go. I mean, he can say, I'd prefer to stay in my cell. I'm sure the judge would prefer him to go because it's part of his trial. The preference is for the defendant to be at the trial. He can forfeit that right if he wants to. But we'll see. I mean, like I said, if he does go, he will be shackled, I'm sure. And the jury will see it. The jury will be able to tell, oh yeah, he's in custody. Sorry, Wisconsin. Oh yeah. I mean, that they'd never have to shackle me in court. They'd just have to take away my leg and say, hop away.
On the record and state versus Brooks appearances are as they were before. Just want to make a quick record. It's not something we need to address right at this moment. I provided to the parties the pattern jury instruction 152 related to jury view, and then an instruction I drafted based on that. And I say based on that because this has to do with the view of the vehicle.
Good friends in Minnesota.
Because I view a view of a scene differently from a view of a vehicle, which is evidence.
When she and her sister get into it,
we don't need to go over this now, but I at least wanted to give those to the parties so that when the appropriate time comes, we can discuss
husband, one of my best
whether
friends,
the court should say
still has the Yorkshire
anything
accent
regarding the view of the vehicle, if that is in fact still the request of the state, and then if so, what that should be. So I've provided that to both the parties in written form. Go ahead.
Actually, I appreciate that, and I wanted to bring this up this afternoon so we can plan. Obviously, I don't know if the mics are on.
It should be. Yes.
Okay. I'm soft-spoken. I'm sorry.
Said no one ever.
Well,
that was all loud. Sorry.
So, with the court's permission, we would like to schedule the jury view to occur at 12 noon
What's
tomorrow.
What's he gonna do? Nibble me bum?
We may not be through testimony at that point with the state's case, but like we did with the interpreter, if we could get a commitment from the court to pause whatever we're doing around 11:45 or 12 noon tomorrow and lead the jury to the location for the jury view. There's obviously some planning that needs to take place by the sheriff's office. The tow truck needs to be arranged, and I believe the maintenance division needs to assist in some way as well. So what I'm learning is that it's best if we just pick a certain day and time and set it, and then, again, with the judge's permission, kind of work around that in the courtroom. So that is our request, if the court is willing to accommodate that.
In regard to that request, I know I had internal discussions with the sheriff's department because they're in charge of security over the trial. And I don't frankly know how much we've talked about this previously. But it is in a secure location, or will be. I've made arrangements, or I've instructed the sheriff's department that because of the location that we will be in, it's not something that will be that anyone can just follow us to, but contemporaneous
vehicle,
recording will be
definitely.
made and then placed into the record so that
I doubt it'll be
the
streamed,
public is
though.
aware of what happened, but after. So I did want to add that to the record. In terms of the request, Mr. Brooks, this relates to the viewing of the vehicle that was recovered by the Waukesha Police
The
Department.
Ford almost
There were
escaped.
preliminary discussions when you were still represented by counsel, and the request is being made that the viewing of this vehicle take place tomorrow. Your response, if any?
I object.
First of all, I accept for value in return for value this paperwork.
That's not a thing.
I guess I'm still confused as to why
You're
there
always
needs to be a jury view.
So they
I
can
can
see
have
the
the state put
evidence.
the
They
their
can't bring
request
the
on the record
car
again.
into the
I'm
courtroom.
responding to their request. So go ahead, Attorney Opper.
Yes, Judge, and I believe the court
They
has
can't
already
bring Main
approved this
Street
request. A motion was
into the
filed and
courtroom.
rolled on by the court previously, but as Mr. Brooks has been charged in every count with acting while armed with a dangerous weapon, we believe it's
They get to
relevant
view
and
the
appropriate for
dangerous
the jury
weapon.
to view what we're alleging to be the dangerous weapon in this case, that is the 2010 Ford Escape.
Almost
It's
escaped.
essentially would be no different than bringing a firearm
Glad
into
to
the
have you
courtroom
here.
during a shooting case.
I don't say it enough. I
And I would
do
just simply
appreciate
note
as I
the
realize I'm
first degree
tiny.
intentional homicide and first degree reckless
Here on YouTube.
endangering safety charges are what carry the
But I appreciate
enhancer
every
for
single one of
use
you.
of a dangerous weapon. Of course, the hit and run does not have that enhancer, nor do the bail jumping and batteries. But with that caveat,
Yes, thank you for that correction, Your Honor.
all right, Mr. Brooks.
I'm confused to that too. Why are there only
Exactly.
certain charges that have an enhancer?
Because
Well,
that's the
not
way you were
gonna answer that,
charged.
sir. Those just happen to be the charges. The state is tasked with proving each one of those charges and any special verdict question that goes along with it. Beyond a reasonable doubt, they bear the burden of proof, as was spelled out in all of the preliminary jury instructions. So that's how I'll answer that. In terms of the
Generally,
jury view,
with
I
a
did
dangerous
grant the
weapon
motion
Is
previously.
an enhancer,
it
not
was
necessarily an
unopposed.
element in the crime itself, but a sentence enhancer.
And I'm not hearing anything that would cause me
They
to
don't have to
reconsider that.
charge a dangerous
In
weapon
terms of
enhancer.
the
They can just charge
time
hit and run
that's being
or
requested, do you
assault.
have any position on that?
They don't have to do assault with a dangerous weapon.
Do I have to be present for this?
I would like you to be, and yes, we're making arrangements for you to be there, sir.
Do I have to be present for it?
You can waive that right.
And also, for the record, I don't consent to the name that's being referred to.
Who cares?
I'll use this opportunity, sir, to ask what name you prefer to be called, because we now have evidence in the record where you provided your name to
Multiple
upon
times.
questioning. There was video from when you were taken into custody. And then,
In
of
the
course, Detective Carpenter has
uh,
testified about that as well. Again,
What
I
call it? Police
try to refer to
Station?
the parties by name because that is how I
Muskego
believe I
Police
demonstrate
Department.
respect and decorum in this courtroom. And we've been given no other name, sir, by which to call you by. And I must, at that point, go back to what's on the criminal complaint, which is the initial charging document. That is what
Exactly.
was filed in order to initiate the case.
She's got to call you something.
When with all due respect, the record should be corrected. I didn't put anything on the
You
record.
did.
That was
It's on the record from video out of
I said
your
there's
said-
mouth.
evidence in the record.
well, evidence. What
There's video of the
You
name
referred that
coming out
evidence
of
to
your
me.
mouth.
So there's evidence in the record, but be that as it may, I'm just letting you know, I'm going to keep referring to you sometimes as defendant, sometimes as sir, sometimes as Darrell Brooks, sometimes as Mr. Brooks.
Late for
I
neutral
understand
oath.
you may still have an objection, but I've been given no other name from you by which to call you.
I follow, but there's still a lack of understanding. Are you referring to the name that was in all caps on all the filings?
That-
Court's
Because
not
every
gonna answer
filing that I
sir.
have,
I
It's
find
irrelevant.
the response to be kind of disingenuous, sir.
so there was
this
no.
is, I believe, a
sovereign
tactic by
citizen
you
mumbo
to
jumbo.
create some type of confusion, which I don't believe there is any, about who you are and what name I need to refer to you as.
I never said you had to refer to me by any specific
does.
name. That's not what I'm saying. I'm saying that every filing that has ever been filed was in capital letters.
That's
That's a
irrelevant.
fact. I have
That's
paperwork to prove
irrelevant.
that. I don't recognize that name, nor do I know any individual by that name. That's all I'm stating.
Well, let's assume for a second that it's
Exactly.
not in all caps. Do you recognize that?
No, I do not.
sovereign
Okay,
citizen
well,
because
we
there
never
were-
answer then. We're going to keep going, sir. We're a little bit off topic in terms of the
He doesn't
request by
want
the
to
state. I'll
go
give you one more
on
opportunity
the field
to
trip
answer that.
tomorrow.
They've requested that whatever we're doing tomorrow
And
morning, whether
he
it be their
objects to
case,
his
whether it
name,
be if you
and
are
has asked
calling
if-
witnesses, that
if
we
she's
pause
referring to the
about
all capital letters
11:45 in
name.
order for the jurors, the court, and the parties to be
But he
taken
also
to that
objects
secure
to
location
it
for
if it's
that
not
jury view.
spelled
Do
in
you
all
have any
caps.
position as it relates to
And
that?
welcome back.
Yeah, my position was when I answered, I said, do I have to be present?
I'm requiring you to be there, yes.
And what
Oh,
reason do I have to be present?
because you're on trial.
Unless you're willing to go through a colloquy with this court and intentionally waive your right to be there, because then I'm going to require you to be there.
Yep.
And that's not explaining why I have to be there, though.
Because you're on trial.
Because I'm requiring you to be there, sir.
It's part
And
of
you
the
just
trial.
made that decision now.
All right. He's not answering the question that I asked him. We will pause
I'm
at
trying to get
approximately
understanding, that's all.
11:45 tomorrow morning for that jury view of the vehicle to take place as soon as we're able to walk over there. But I think given the logistics of everything, it is on campus, but it is in a secure location. That will take place approximately at noon. And as I indicated, the court will require the sheriff's department to make a contemporaneous video of that view, which will subsequently be made part of the record to capture that.
Don't I have rights, though, Your Honor?
All right, then with that,
You do.
Go ahead.
Scheduling, Your
And
Honor.
requiring you to be there.
Could
is
you please
protecting
indicate your intentions
rights.
as to how late we will proceed this afternoon so we can line up witnesses?
sure, I'd like to try to, we had a little bit of a long day yesterday, so I try to balance that out for the jurors.
He's
So
Remember,
generally
he's
between,
starting after
4:30 and
lunch
5 is when I
on
would like to break, depending on where
cross-examination
we're at. If
of
we need to go a little earlier because of the
detective.
witness, or if we need to go a tad later, that's fine as well.
it's going to be
Okay.
a mess.
And then the last
It
item,
could
Your Honor, is
Go for
that,
days.
to my knowledge, we still have not received
past
anything
is
from Mr.
prelude.
Brooks as to the date and time when he would like his witnesses ordered to appear. I don't see anything was e-filed. So if he is still requesting the assistance of the state,
Which they don't
to
have to
secure
provide.
the appearance
It's
of
not
those
their
witnesses,
job.
we will need that information, Your Honor. He does not have to give us the exact order, but if he could tell us,
It's not the state's job to secure
as you
his
had suggested,
witnesses,
either morning or
They're doing
afternoon,
it as a
and what day of the
courtesy,
week he
but
wants
he's
these
not
people here.
cooperating with that either.
We have served the subpoenas that he requested at his request in order to assist him.
He's
And these
intransigent
witnesses
in every
obviously
way.
have jobs and other commitments, so it's reasonable to be able to give them a time frame on when they need to be here.
Mhm.
With that, when do you expect to rest?
We're still hoping to rest by the close of business tomorrow, Your Honor, unless something unforeseen happens.
Unforeseen, as in this cross-examination taking
So
3
we're talking
days.
about Thursday and Friday at this point.
Yes.
Which is what I suggested from the beginning yesterday.
Except
But
they
Mr.
didn't
Brooks, we
know
need to
yet
know
yesterday.
Which particular witnesses on which day and whether it's AM or PM. Don't need to give me the order. We'll have them come in groupings, but it's not reasonable that they all come on the same date.
I never
So-
said it was.
All right, so you need to provide that to the DA.
How am I supposed to provide that to the DA?
You can write that down, or you can put it orally on the record right now. I asked you to bring
He's
it with this
refusing to
morning, and I didn't
cooperate.
cover that this morning, so you were put on notice
I
of
mean,
that. But I'll
this
give you
is
until.
the DA doing
notice
him
of
a
what?
favor
Um,
that they don't have to
Let
do.
me ask Attorney Opper a question. Would tomorrow morning first thing be sufficient for the state to make those arrangements, given that you don't believe you will close your case until the end of the business day tomorrow?
I
He's
understand what the court's saying. I think that's
terminally
reasonable
incapable
with the understanding that
agreeing
if somebody
even
needed to give notice
to
to an
accept help.
employer and it can't be accommodated, then that may affect things for Mr. Brooks. But I think 24 hours
mean-
notice is generally reasonable.
You've heard,
And we
don't
will do our best.
don't look a gift
We
horse
can-
in the mouth. He's punching the gift
Sure, the
horse
court,
in
we
the
will
mouth.
do our best to get them here. But I don't know if we'll be able to exactly accommodate the timing that he may or may not want.
All right, so Mr. Brooks,
Objection
to
to
be,
that because
Objection
when
to
the-
them
when the,
not being
subpoenas
able
was
to
served
help
to
me.
them,
and
I'm assuming that they would have let any employers or anything know that they were expected to testify in a trial.
they don't know
I
when.
don't understand why it will become a problem at the last
They
second.
don't know
well,
when.
if you recall,
have to
sir,
give
at the
them
end,
notice
near the end of
when.
last week, I don't recall exactly what day we were on, but we knew we weren't gonna finish with the state's case at some point. And we had a discussion on the record. If there was any objection by you,
At,
if
at
the
this
state
point, if I'm the state, I just
told
say,
those witnesses
you know what?
they didn't need to appear on
Get them on
Friday,
your
so
own.
it obviously had to have been before
get
Friday.
them on your own. We're done helping you.
That they didn't need to appear and that they would work with those witnesses to provide them with a more
if he's
definitive
not going
time.
to give me what I
So
need
now
to
is the
help
time
him
when we need to
with something
provide them
I
with
don't need to
more
help him on,
definitiveness.
I'm done.
So by the start of court tomorrow, you need to bring with you either in writing or be prepared to put it on the record orally,
He
which
won't.
witnesses you want. We'll start
Guarantee
with
he
Thursday
won't.
morning, then Thursday afternoon, Friday morning, and Friday afternoon.
He won't.
I don't need to know the
There's
order,
no way
but I
he
need to know
does.
the day of the week, right? So Thursday, or Friday. I would just note the dates for those. Thursday is the 20th, Friday's the 21st, and then which witnesses. Only you know how much you want to question them, so you should be able to gauge if we can get 2 in each morning or afternoon, 3, 4, whatever. Use your best judgment on that.
Yeah, I don't know how I'm going to come up with exacts on that.
I presume you're going to prepare some questions and you might be able to kind of gauge how quickly that will go or not. If not,
No.
we'll do our best,
If
but
the
you've got to
prosecution
provide some
did nothing
definitiveness.
to help him,
It's not reasonable
it's
to
not
just
grounds for
have
appeal.
these witnesses all come
Because
on
it's his
one
job
day.
to secure his witnesses.
I'm informed of what you're
They're-
saying.
they're
I just
going
feel
over
like
and
that,
above.
that same courtesy wasn't afforded to me.
You
by the
didn't
prosecution.
procure
They
the
didn't have to tell
witnesses
me
for the
exactly what
prosecution.
witnesses was being called on what day and all this and that. Why is it not
They're-
even
We are
planned?
I am
didn't
requiring it, sir,
secure their
because they are
witnesses.
assisting you because they graciously agreed to do that because you are representing yourself.
And they should say, you know
if
what,
you want
do it
them
yourself.
to be out of the loop on that, then I can just put it on your responsibility and your shoulders. But that is up to you.
What do you mean by put it on my shoulders?
You can
Get them
contact
yourself.
How am I supposed to do that?
That's
You have
your
access to a
problem.
phone in the jail.
That's your
so I'm
problem.
supposed to call everybody that I subpoenaed,
Yes.
not knowing their information.
Yes.
That is one way to do it, sir. Their information is in the police reports.
That is highly unreasonable.
No, it's not.
When,
How's
one
the
person
prosecution
That's
going
on
to
my
get them
witness list.
there?
I'm not even
The
permitted to have
prosecution would
contact.
get
That would
them
be a
there
good
by
exception
calling
to
them
that.
and
So that's
saying,
very
"Hey,
astute of you
need
to
show
point
up
that out,
this time."
sir. That would be one exception.
You can do that
But
too.
other than that, in any event, sir, we're kind of a bit
they
off
do not
track.
have to help you.
We're going to get back on track.
I
and you
would
need
have
to
already
provide the
said,
information
do it
that's
yourself.
provided
I'm
that
done.
I've outlined here today.
I don't think that's fair, Your Honor.
Oh, your objection is noted.
It's
It's
not
my ruling.
fair.
The state didn't have to do that, but I
It's
have
not
to do
fair. It's
Sir,
not
I
fair that
remind
they're
you
helping
that you are nonetheless required
It's
to
not
follow the
fair
rules of
that you expect
procedure,
the prosecutors
just as
to do
any
the
attorney
defense
would
attorney's
have to
job.
if they were representing you.
It's
You've
not
chosen
fair.
to represent yourself. The state has graciously agreed to assist. They've served the subpoenas on your behalf. They didn't have to do that, but they did. They've agreed to contact the witnesses throughout so that a better idea can be provided to those witnesses as to when they need to testify. They're simply asking for some basic courtesy.
He's incapable
So
of
they can then
courtesy.
relay that information to
He
the
doesn't know what
witnesses
courtesy
you
is.
want to
It's a
call in
foreign
this
concept
trial.
to him.
I'm informed of that, Your Honor, but
All right,
That's-
then let's move on.
that's
I can speak
actually under
Swahili
the
better than he.
confrontation clause in the Sixth
can-
Amendment. I should be able to have the right to have witnesses subpoenaed.
And you could have
shouldn't-
subpoenaed them.
Why is that?
Again,
being
we're getting a
overlooked?
little
It's not the
far afield
prosecution's
here, sir.
job under the
Subpoenas were
Sixth
provided
Amendment to
to you. The
subpoena
record
your
is very
witnesses.
clear on that. We assisted you with that. I even reviewed them for completeness. And then the state assisted you with serving them. That is something they are not required to do, but they agreed to do in this case. So nothing about your Sixth Amendment has been violated in that regard.
Did I
You're
say violated or
calling these
did I say I'm
witnesses,
not?
So that's you need to understand that.
It's
sir.
your
I don't
problem.
understand anything. And
It's your
For the
problem.
All
record,
right.
I didn't bring up the word
let us
violated.
continue then. We're going to move on, Mr. Brooks. Let us
So-
continue with the
so we gonna
questioning
move on to
of.
subject matter jurisdiction that
No,
has
I'm
yet
not.
to be proven.
Detective Carpenter, you can please come on back up to the witness stand, and Madam Clerk, you can have the jurors brought out.
So we're not going to address that at all. That's not going to be proven for the record.
Gag him.
Is that a judicial determination that you don't have to answer the question, Your Honor?
She does not have to answer any of your questions.
Is that also a tactic agreement?
The state would move exhibit 82 into evidence. This time,
All right, you want to do that in front of the jury or just with me?
I wasn't sure if the defendant would have any objections that would need to be heard off the record or outside the presence of the jury.
Well, can you have them hold for a second? Do you have any objection to Exhibit 82?
Yeah, I got objection.
What's the objection, sir?
What is the relevancy of Exhibit 82?
82 is your interview with Detective Carpenter and Detective Stern. Your objection is to relevance?
That's why I shout over him so that
Your objection's noted, it's
You can be
overruled,
annoyed
and
by
I
my
will receive
voice
Exhibit
instead.
82.
The court will let the jury know that when they
So
come in.
are
Yes.
you overruling the
but
fact that
he is so aggravating.
the true nature and cause has not been presented to me? That I don't know what the true nature and cause of the charges are?
Murder is the charge. If you don't understand what murder is, I don't know what
You
to
can
tell
have them
you.
brought out now. All right, thank you.
But now is clearly the time to argue since the jury's on its way.
All right.
Your Honor, may I see a sworn affidavit?
The
of
jury's
nature
coming
and
in.
duty of the
Shut
court?
up. Seriously. You notice he
Or is that
waited
a
until the
judicial
jury was
determination? You don't
walking
answer that
in.
as well.
Welcome back, ladies and gentlemen of the jury.
Or if the record reflects that.
Shut up. It's going to be hard to cross-examine the detective from the other courtroom. So shut up. Stop muttering.
All right, thank you, everyone. Please be seated. Record will reflect that Detective Carpenter is back on the witness stand following the break for the lunch hour. And Mr. Brooks, you may start your cross-examination.
I don't consent to being called that name, Your Honor.
Your objection's noted. It's overruled. Please ask your
Can't be
questions.
overruled.
You can't overrule my objection.
Detective Carpenter.
He's got a little glee in his voice there.
Did you attend the parade that evening, November 21st of 2021?
Yes,
In what capacity?
as a member of the honor guard.
And what
That's
time
right.
did you arrive?
He did testify yesterday. He was honored.
I don't recall the exact time.
What time did you leave?
As was Officer Chris
I don't
Moss.
recall the exact time.
And when you left, where did you go?
Our temporary police department.
Temporary. Explain what do you mean by temporary?
The permanent.
So at the
was
time of the
remodeled.
incident,
That's why they took you to
the
the
building we are in currently, which was our
Muskego
main building, was under
department.
construction. So we were displaced.
What do you mean by at the time of the incident?
The time you
Time of the
rode
parade.
over the parade.
And so
I'm sure YouTube
The-
appreciates that static.
the regular station was, what did you say, under some type of construction or something?
Yeah.
Correct.
And so what were you guys using for the temporary police station?
For your purposes, the Muskego Police Department.
The city
Station.
annex and city hall. We're in two different buildings.
Does any of those buildings consist of a room for interrogation?
There is at the annex.
But they didn't use it because they took you to Muskego.
And so when you initially interrogated the suspect, why was the annexed interrogation room not used?
Because they took you to Muskego.
Well, when I interrogated you, Mr. Brooks, the annex room was not used because
You were held in a
the
cell.
situation was
in
very
Muskego.
fluid. There was a lot of information being learned. We knew this was going to be drawn out. There is no municipal lockup facility at the annex, so it could not be utilized.
This isn't helping
And
him.
so the
I mean, does
police
he
holding
really
room
think
in the
this
hospital
impacts
was more
the
sufficient.
detective's credibility?
You asked to go up there for medical clearance.
So the police holding room in the hospital was more sufficient than your temporary station, which would have been
For medical treatment.
more suitable.
Did you want medical
Yes, it was
treatment
more
at City
sufficient.
Hall?
And why would a hospital police room be more sufficient than the actual police station that you were
Because
utilizing
you
at the time?
wanted medical treatment.
As I stated in my previous testimony, there was no secure lockup
You had
facility
a
at the
boo-boo
station.
on your shoulder.
In addition to that, you requested medical clearance at the hospital.
So was there sufficient lockup at the police room in the hospital?
We had areas in the hospital.
This
So
is
when you
going
were
to
being
take
treated
days.
by the doctor, you could be handcuffed to a bed.
This is going to take days at this
There is
point.
no place in the interrogation rooms you referred to at the annex to handcuff you to anything, and the doors did not lock sufficiently.
And to the best of your knowledge, would a detainee have that information that you just stated?
Why would they? How does that matter?
So
That I mean,
how come the suspect couldn't be handcuffed at the annex for the interrogation
because you weren't at the
without
annex.
having to be handcuffed to a specific bench or whatever you refer to it as?
Well,
I guess essentially what I'm asking is could the
That's
suspect
what he's
still
doing.
be properly detained while being interrogated at the annex versus
Tie
police
his own
holding
noose.
room in the hospital?
so let me make sure I have this straight. Your question is about
The
detainment?
detective
Do I
is
have that right?
confused.
I think the question was very clear, Detective.
I can't answer it if I'm not going to get clarification.
He's such an ass.
And where was the suspect taken upon being detained?
The hospital.
You were taken, Mr. Brooks,
I like
Upon
how
the time
Brooks
you
is
were
like, where
arrested,
was the suspect
down to
taken?
the substation
You were taken,
on West
Mr.
Paul Parkway
Brooks.
in Waukesha.
And do you recall if the suspect was put into a holding room?
He spent far too much time with
Yes.
him in the interrogation room.
And
He hates him.
do you recall if that holding room had something that would secure a detainee?
Yes.
So why couldn't the interrogation happen there if the suspect can be secured at that location?
Well, there are various reasons, and one of the most important reasons is when we took you to the hospital, Mr. Brooks, for your medical clearance,
They weren't ready yet.
there were now
They're not
a total of
interrogating
4
you
officers
on
there.
your
Myself,
timeline.
Detective Stern, and eventually the 2 federal agents.
Exactly. It's a holding room.
The
not an
situation was still
interrogation
very
room.
fluid.
And they do it
when I
on
began
their
the initial
timeline.
or the initial questioning, it was 11:04 p.m. And
So
there was
they
still
waited
a lot
till
of
morning.
unknowns. So the determination was made to start questioning you, see what information you might be willing to provide us. Because with 4 of us, we were confident we would be able to keep you where you belonged, where we needed you to be, as opposed to risking another unnecessary transport. Because and it's not just personal against you. Any transport of any prisoner, there's a risk. So there's no point in taking that risk of that transport when we had the ability to do the interview there, especially when there was such limited information that we had.
So FBI agents were present at the substation that you referred to?
They arrived there at one point, yes.
Was that known to the defendant?
I don't either. It's
I don't
how
recall.
is the location of the interrogation impeachment?
Is it fair to say
It
that
doesn't go to his
the
credibility.
detainee could have been?
It doesn't go to the truth of what the detective has testified about.
Is it fair to say that you could have made sure the suspect was contained while at the substation, seeing as how that there was multiple officers present?
Who cares?
I think this has been asked and answered.
Over and
the
over and
substation versus
over.
the hospital, so I'll allow it. Overruled.
You were contained initially at the substation, Mr. Brooks.
He
But
might.
you requested
I
medical
don't know.
transport, so you were transported. So what I'm explaining to you in my prior testimony is
We'll see.
I didn't know
when
at that point
gets a
if you'd end
chance
up
to
going straight to
ramble
the county
to
jail
the jury.
or what have you. Every transport, as I stated in my earlier testimony, there is a risk. There is a danger. It's not just personal to you, it's any prisoner. So the decision was made to start the interview there based on not knowing where you'd end up for sure, not having all the information.
I'm sure there
that
are
we weren't
many
gonna take the
people,
risk of it.
many people
an extra
who
potentially
share that
unnecessary transport.
sentiment.
Transport back to that facility, you couldn't be held there. You couldn't be held at the sub. There's no beds.
So
you
why
referred to
not interrogate
interrogation
him
starting
somewhere where they can then
at a
just
specific
put him in
place?
a cell?
I'm referring to the substation. Is it fair to say that there was no interrogation that took place at the substation?
Yes,
Yes, that's fair to say.
Yes.
there was no interrogation at the
He
substation
said yes.
in Waukesha.
They may have been chatting
Do
with
you
you,
recall what
that
information was
isn't
obtained
necessarily
at the substation?
interrogation.
Yes,
Do you recall what that was?
They
Yes.
were probably talking football with
Can you
you.
stay for the jury and for the record what information you
For
obtained
the
at the
jury and the
substation?
record.
Yes, sir. Basic biographical information. So I obtained your first name, Darrell Brooks. Your last
Oh,
name being Brooks. Your full middle name, I should say, being Edward. I learned that you were a junior. The date of birth, February 21st, 1982.
it could be.
Additional information obtained was your home address, which was you provided as 4014 North 19th Street in the city of Milwaukee.
He's gonna
Phone
miss
number,
his
your emergency
protective
contact,
custody
which you
at some
provided as
point.
Dawn Woods, whether you were employed, going to school. I remember talking
And don't
with
get
you
me
about your
wrong, I'm
tattoos and other
against prison
physical marks that
violence.
might be in
I'm
your
against
body.
prison
Your hair color, eye color,
sexual
photographs
misconduct.
were taken, things of that nature.
Kept mentioning that name, pretty slick.
Stop with the commentary.
Sure, disregard that last statement. Sir, please ask questions. You'll have an opportunity to
Uh,
testify later.
Oh, I got a lot of questions.
Then ask them. Stop with the commentary. If you keep up the commentary,
And at that point in the
cross-examination will
investigation,
end
what
real
did you
fast.
initially know?
At that point, we knew that the red Ford Escape had driven through the parade route and that you'd been identified as a suspect.
And why was that information not provided at that time
To you,
to the detainee?
because they didn't have to.
The information at the time wasn't presented to you,
It's
Mr. Brooks,
strategy
because,
for
as I
interrogation.
stated in my earlier testimony, it was still very fluid. It was very chaotic out at the scene. There was still a lot more that needed to be learned.
It's
So
called
is that standard procedure
strategy.
to not tell a person why they're being detained?
They
Well, we
don't
did
have
not
to tell
tell you.
you
That's
everything.
incorrect, and it's misleading to the court. You were informed you were being detained for prowling, loitering, disorderly conduct of that nature.
Is
I
that the
just didn't
same
bring.
as
Can I finish, please?
Stop
I just didn't
interrupting.
bring up the parade part of it.
why not?
Strategy.
As I stated in earlier testimony, it was very fluid and chaotic, and a lot of information wasn't yet known. So I was waiting to receive more information.
Did you state in your early testimony if that was standard procedure or not?
It's standard.
So with every detainee that you've ever detained during your career, 18 years, right?
Yes.
It's standard procedure to not tell someone being detained what they're detained for.
He didn't say that.
As I had stated in my earlier testimony, Mr. Brooks, I explained to you you were detained for prowling and loitering and disorderly conduct. Based on the lack of information on the parade, that was not brought up. So what I can clarify for the court at this point is that
Oh
in
yeah.
situations where so limited information exists early on,
I mean,
it
Brooks
is
is my
standard not
size,
to convey
and
that
I'm not a
information
big
to
guy.
suspects.
And what do you mean by it's standard?
I mean that I don't tell them because I don't have all the facts yet, and I'm not looking to necessarily accuse them before I know the
He
nature of
doesn't
what
always
they did or
tell them
didn't do exactly
because
pertaining to
he's
that
hoping that
So it'd be
they
fair
will
to say
tell
that
him.
it was
It's
not a fact
strategy. It's chess.
as far as the information you learned to that point in the investigation.
Jesus.
Objection there.
Grounds.
Sustained is to the form of the
It's
question.
vague. It's argumentative.
So at that point in the investigation, it wasn't a fact.
Objection, same question.
Grounds.
Sustained is to the form of the question.
At that point in the investigation, the information you had at that time, you weren't sure about.
Not yet. Not all of them.
I guess which part?
All the information that you had up until that point.
He had all the information he had
About
up
the
until
prowling
that
or
point.
parade? I don't understand which part of it you're talking about.
All the information that you've obtained
Exactly.
at that point in the
It's
investigation,
poker. You keep
you
your
weren't
cards
sure
to your
about. As
chest.
you just said, you don't try to assume
Why would he tell you
guilt or
so that
anything
you
like that
clam
until
up?
you have all the facts. So at
You
that
knew what you
time,
did, so you should have
at
clammed
that
up.
point in the investigation, is it fair to say that the information that you had obtained
I
so
think
far,
the reason
you were
Brooks
not
talked
sure
to
about?
him is because he was trying to get from the officer.
I wasn't sure if
from
you were the
detective,
driver
what
initially.
he knew.
but it was believed you were involved.
And you knew that to be fact?
Yes, the information being provided was that you were involved.
So it'd be fair to say you knew that as a fact.
Yes,
Well, hold on, I'm gonna.
that's for the jury
Not
to
allow him
decide.
to answer
for
that.
the first
This
part.
jury will determine the facts of this case. If you want to ask him his opinion, you do that at your discretion.
He said fact.
You're
said that.
asking
You
him if
asked
it's
the
a
question,
fact.
sir. So
But he brought it
I'm
up
gonna,
first.
You
I'm going
asked.
to
It's for the
strike the
jury to
question
decide.
from the record. And Mr. Brooks, you're directed to rephrase.
I will rephrase, but I do not consent to being
Every
called that
day
name for the
is
record.
shut the fuck up
Noted and
Friday.
overruled.
You stated that there were some loitering and prowling
Loitering.
allegations. Why? To your knowledge, were those ever charged? Grounds.
Overruled. The witness may
It's
answer.
irrelevant because
No,
he's not on trial for them.
And
It's
do
the
you recall why
prosecution's
not?
because it's prosecutorial discretion.
no.
It's for the prosecution to decide what to charge. I think they generally strike a line through it.
So why did you constantly tell the detainee that they were being detained for loitering and prowling if you in fact knew that there
Because at the
was another reason
time,
why they were
you
being
were
detained?
loitering and
Objection
prowling.
asked and
Grounds.
answered.
Sustained. That's the form of the
They
question
can.
and assumes facts not
They
in
can.
evidence.
So they could have told him, you're being detained so we can bake you a birthday cake. It's complete BS. It's a lie. They could have told him that. He's dumb enough to believe it.
What was the significance of the FBI being present?
They were there to help.
The significance of the FBI presence was the early on concern.
They were
that this was a
investigating it as
terrorist-style
terrorism.
event.
Terrorism's a federal charge.
And you said that this was a terrorist element. And what is the
They were
this? Can you
investigating
explain what
it
the this is?
as.
When you drove your vehicle through the parade and struck people.
Which at the
Exactly.
time you stated you did not know is fact, correct?
He can't say it is a fact.
That
It's
was
for
still
the
being
jury
investigated,
to
yes,
decide.
but I know that's what occurred now.
Now versus then.
When?
Initially, it was unknown if you drove.
That's what I
as
was
stated.
that was the question.
But
By the
The
time
investigation
they
showed that you were the
interrogated
driver
you
of the vehicle.
the next morning, they had video of you.
And initially you
in
didn't
the
provide that
vehicle.
information, correct?
correct.
It takes time to gather
So do
evidence.
you know if the FBI continued their part of the investigation?
Eventually, the investigation was strictly run by our department.
And do you recall why that decision was made?
They decided to charge you with murders instead of terrorism.
My understanding is there wasn't a terrorism link.
And you're not charged with terrorism. But you keep bringing it up so that the jury keeps hearing the word terrorism.
I'm sure throughout your career you've done lots of interrogations. Are there usually multiple officers that do the interrogation, or usually just one?
It depends.
It can depend on the circumstance. It's not always more than one, but it can be.
And what would you estimate would be the normal
And at this
procedure
point, they
for
had
interrogation
reasonable
as far as
suspicion
law enforcement
that he had
wise?
driven through the parade.
I really can't speak to that. I think every department
They didn't
probably
have
has
to
their
tell him
own
that
potential
yet,
way of
though.
doing things.
They just had to have a
Up
reason.
until that point in your career, when you interrogated the detainee, had you ever conducted an interrogation with FBI present?
Not prior to that date, no.
So clearly, you were the worst person he ever interrogated. Is what I take from that, if I'm a juror.
You made reference to car key being found. Do you recall that?
Yes, I do.
Did you yourself find the car key?
He
No, I did
wasn't
not.
the one that arrested you on
Were you
Elizabeth
told
Street.
by other law enforcement?
They found it in your pocket with
I
your
guess told
credit
what
cards
exactly?
and a sandwich.
That a car key was found?
Yes,
I was not
they put it in
specifically.
evidence.
Your items that were located on you during the search were turned over to Detective Stern, and the car key was one of those items.
It was in evidence. That's all he
And
needed.
to the best of your knowledge, you didn't have that information at the time, correct?
At which time?
And at the
He's
time
so
that
vague.
at the time that the detainee was detained in the substation.
I mean, if I were a juror,
Thank
I'd
you
have
for that
been ready to
clarification. Go
hang
ahead and
him for wasting my time early last week.
I just want to make sure I guess that I understand. So you're asking me what I knew about the key, or if I knew where it was found at the substation? I don't understand. Can you clarify that, sir?
I guess the clarity that you may be looking for is
I mean, that's a good point. He asked the detective
what was found and brought into the
Leha,
substation.
was it? Who the one who had him on
Okay.
Epstein watch?
The Ford ignition key and
Are you sure I was sleeping?
other items that I
The
alluded to in my
interrogation was
earlier testimony,
after
include your
he
photo
slept.
ID and
So,
credit cards with your name.
are you sure I
Or
was
debit card,
arrested?
credit
Are
and
you
or
sure
debit
I was
cards with your
coherent?
name on it.
Coherent.
That you did not search and find yourself, right?
That's correct.
Did you conduct any searches?
I don't recall if I did or not of
He
your
was busy
person.
with you. Epstein. Make sure he didn't
So it'd
off
be fair to
himself
say you don't
in
know
his
where
cell.
certain items were found at the time that you learned of there being items found, correct?
No,
No, as in
No. And
no. I knew those items were found on you in the search. Maybe not the specific pocket, but I knew the officers found those items in your possession.
were you at the scene of the
Possibly.
search?
No,
So how do you know where they were found?
because they were turned over to Detective Stern as your property.
How do you know where they were found though, if you weren't
it
at the
would
scene?
have been in the report.
Because I was aware officers searched you, and it's not reasonable to believe they were randomly in the grass at the house you were at in a city that you've indicated you're not familiar with.
Can you strike that last answer from the record? I didn't refer to any house, grass.
You asked
City.
an open-ended question. His answer will stand. Your
If,
request
if
is
you
denied.
ask an open-ended question,
So it'd be
you
fair to
get
say
an
that
answer.
in the
Ask
question,
yes
I
or
did
no
not mention a
questions
house, grass, or
on
city?
cross.
That'd be fair to say?
You didn't mention it, but I know you were found at a house in the city of Waukesha. And I know you're not familiar with Waukesha because that's what you told me when I interviewed you.
He's so
Can you strike
annoyed.
that last answer?
No,
Request is denied.
On what grounds, Your Honor?
because
You asked the question.
you
He
asked-
answered it. If you want to
if you
limit,
don't
ask
want him
leading
to say
questions.
something, don't
and
ask a
direct him.
question that leads to it.
That is your right.
You
During
made
cross.
you made reference to the house where the detainee was found, the grass, the city.
By bad witnesses, I assume you mean bad for him.
Could it be possible that that's where they were found?
The police have
items
been
that
great
you-
witnesses for the prosecution in this trial.
Are referring to?
No,
Even though it'd be fair to say that you were not present.
correct.
You made a lot of reference to
Of course, I'm the one that brought him up, so calling it Epstein watch instead of the S
the
word
body
watch.
pain and having to be checked at the hospital and being medically cleared. Would that be fair to say?
Yes, we took you to the hospital for clearance.
Are you yourself a doctor or have any training in the medical field?
That's why they took you to the
No, sir.
hospital, moron.
So it'd be fair to say that you cannot know how a person's body is feeling. That'd be fair to say?
That's why they took you to the hospital. You wanted medical treatment. He took you to the
I
hospital.
can't explain exactly what another's body's feeling, correct?
So it'd also be fair to say that there's a possibility that you can be incorrect about assumptions made to pain reference. That'd be fair to say?
Who cares?
I think that depends on the circumstance.
You seem
In this specific
perfectly fine
circumstance,
until he
you
makes
told
you
me.
squirm a little bit.
Follow up if he wants it.
okay.
Once he makes you squirm, oh, my shoulder.
You made a reference on one of the exhibits. I'm not sure exactly which one it was.
Then you should have written it down.
It was the
That's your problem.
first interrogation in the police holding room in the hospital. In that exhibit, you made reference to the FBI being present because you were short-staffed. Do you recall that?
It's not because they were short-staffed.
I don't
It's
recall
because
exactly what
it
I
was a
said, but I recall
massive
acknowledging
event.
their presence, yes.
And you made a reference to short staff. Can you explain what does short staff mean?
It means every
I don't
single
recall if I said that or
police
not.
officer was needed because you drove through a parade.
I don't know if it's exhibit 172 I'm referring
That's
to.
your problem. You should have written it down. You should be
Can you
prepared.
pull up exhibit 172, please?
You refer to the photo of the identifiers and the items found?
Is that
It's
172?
yes.
Well, I don't think, is it 81 then I'm
Terrible.
referring to?
81 is the
Terrible.
audio recording.
Okay, it's
I'm
81
sorry, 81 is the video and audio.
of the,
Is it just the audio? I was right the first time. It's
okay, I think it's 81.
You would like the audio recording from the hospital.
Yes, Your Honor.
Is there a part you'd like to direct the state to when they pull
He's
it up?
gonna kick open the door.
Because it's the audio,
I guarantee he'll
I'm
kick
assuming
open
it'd
the
be
door
probably as soon as the defendant is brought into the room.
as soon as you're brought in.
It was played starting at 4 minutes and 25 seconds through 14 minutes and 25 seconds. Do you want it started right at 4:25?
Yes, Your Honor.
Okay. The state would please assist with that.
How long would you like it to be played?
Do you know how long you want it played, or do you want the whole thing? The
I don't-
same clip?
I don't need the whole thing played.
Then give them a night.
From what I recall, the point that I would refer to is pretty early in that.
Well, how about we start at 4:25?
He's
And
maddening.
you say pause, please, when you want it to be paused by the state.
Okay.
All right, go ahead.
And I guarantee this won't help him. Because if she doesn't, no one will.
I'll tell you.
Darrell?
Yes, sir.
Darrell.
Oh,
I'm,
they're playing him,
Wachowski.
confirming his name again.
FBI.
I'm Mary. Yep.
It's being
They're
put
just kinda helping
in
out
as
'cause
evidence again.
So short-staffed tonight.
That is his name.
Thank you.
It's paused at 4 minutes and 56 seconds. Go ahead.
From hearing the audio on this exhibit 81, do you recall saying that the FBI was present because you were short-staffed.
That is my voice. I don't recall saying it in the moment, but that's my voice.
That is your voice.
That is me talking.
So
Beam
from your
him back up.
recollection, do you recall being short-staffed at that time?
Yes.
Who knows?
And can you explain what the short-staff mean as far as
It means you
that
committed an
time,
act of
what was
such
short-staffed mean?
tremendous magnitude that they didn't have
That
enough
we were
police
just very short
officers.
on resources with what happened
They had a massive scene to secure.
down at the parade route and the mass casualties and the amount of officers it took to secure that
This
location. We
is
were
such a stupid line
very
of
short on
questioning.
people.
Once again, it's
And you
reminding
made
the
reference-
jury about
you
how
made
bad
reference
this
to the
was.
short staff being the reason why the FBI was present.
Because they were helping you,
Yes.
them. FBI is law enforcement. It's just like neighboring cities' police officers were helping. It was an
Is
event
FBI
of such
usually present?
magnitude.
In the situation of short staffing?
No.
It's just like the state highway patrol, I'm sure, was involved. I mean, the fire chief, the assistant chief who testified said they called
forgive
in
me.
additional
I'm sorry.
alarms
No,
on
it's
the
okay. I just want to make sure if you needed it. So
fire department
Taking it.
emergency. Exactly.
Mm-hmm.
It can be they needed at all hands and they were investigating terrorism.
And you
Why
made
not both?
reference to recording the interrogation on your phone, correct?
Yes.
And why would you use your phone to record an interrogation,
He already said
especially one of this magnitude?
compound. Objection.
Because the
compound.
camera in the room didn't have audio capability.
Because it was at the hospital.
And were you informed of that? Or let me back up. When were you informed that the camera that was in the room did not have audio?
I don't recall exactly. Prior to the interrogation.
And who were you told by?
The hospital administrators.
Hospital security.
Was that the first time you had ever used that police holding room in that hospital?
No.
Except then
So
it would have been
be fair to
federal.
assume that
So
you
no
were aware
cameras.
that room had cameras.
But
Yes, I knew it had cameras.
if he had been tried
And have you ever
federally,
conducted
the
an
death
interrogation in
penalty
that room before
probably
that
would
evening?
be on the table.
Interrogation, no.
If
but
not,
I've used the
he'd
room
be
for
at
other purposes.
ADX Florence for life, I'm sure.
So what prompted an interrogation in that room that specific evening?
Because you were there for medical
Well,
treatment.
as I explained in my earlier testimony,
And they
the
wanted to get
situation
started.
down in the downtown area of Waukesha where the mass casualty incident had occurred was very fluid. It was still unfolding at that time. We were learning more and more and more about what occurred. We decided to start the interview at that location to see if you'd be willing to shed light on for us as to what you did or did not know. And again, I'll go back to statements I made earlier. There's a risk inherent with every transport. I didn't know where your ultimate final location was going to be that night. So to
Federal
now start
judges are
bouncing you from facility to facility
notoriously
to facility unnecessarily was just something we made the decision not to do.
not patient.
And at some point,
They have no
the
patience.
detainee
for
was
nonsense.
moved to the Muskego Police Department, correct?
Yes.
Yes, you were moved to the Muskego Police
And
Department.
put in
later
a
the year.
cell.
And when did you learn that that would be a location that the detainee would be going to?
We made the
After
decision to
driving
try to
around
use that
in circles for
location
a couple hours.
after the first interrogation attempt.
I'm sorry that I didn't hear the last part.
I'm sorry, after the first interrogation attempt.
They probably could.
First interrogation attempt. How would you define attempt?
Well, when we were at Waukesha Memorial Hospital that night, in the
But
police
like I said,
holding room
even
that
if
we
they didn't,
discussed,
if it were federal
I
charges
read
and
you
a
your
federal
Miranda rights
conviction,
verbatim from the Waukesha
ADX
Police Department
Florence
Miranda statement form.
is the worst it gets.
And at that time, you indicated you didn't wish to speak with me.
So it would be fair to say that the Fifth Amendment right was exercised at that point
No,
Right to silence.
you didn't invoke.
under the
You
Fifth
didn't
Amendment.
ask for
Yeah.
You didn't ask for an attorney.
So
I'm sure you can.
acknowledging now the fact
They'll
that the Fifth Amendment
be
right
even
was
more
invoked not to speak, where, as you say,
thorough in
the
the
right to
Breda.
silence. Why did you continue to record on your phone?
So we are trained at our police department when you do an interrogation, the recording is to be left on.
You can go pro se with the feds.
Pretty much until you try to
Like I
effect
said,
transport.
first trial I ever saw.
So typically what we
in
would do is
person
if our building hadn't
was
been under
a
construction,
federal tax fraud
and
case.
we've been able to get you back to our police department, where in
by a
that
sovereign
situation we
citizen, and he was pro se.
may very well
He
have
did have
transported you,
standby counsel,
just
though.
because we would have had a municipal lockup there and we could have held you for the night. But that again was difficult based on the fact that we didn't have that possibility at the time. So if someone's in an interview room and at our police department, we'll leave that, even after the interrogation's over, we'll leave that video running until we come back and remove the individual from that room.
Even once a detainee has invoked their right to silence, you still continue to record?
Did you
Is that
positively
a standard
invoke
practice
it,
of your
or did you just
agency?
remain silent?
Yes, it is, for as
There is
long
a
as they
difference.
remain in the room.
And so when did you start recording?
Recording
Are you talking at
has
Waukesha Memorial
nothing to
Hospital?
do with you
Correct.
invoking
Prior
your
to
Fifth
you entering the
Amendment.
room.
It has to do with them questioning you. They can still
So you
record in
started
case you
recording
start
before
talking
the detainee
spontaneously.
entered the room, and you said you keep the recording on until they leave the room. So would it be fair to say that there should only be recording while the detainee is in the room?
No, they can record, period.
And you did say for the record that that's
Exactly. If you keep
standard
talking,
procedure in your agency.
you've waived
In regards
But
to the
even
interview
then-
rooms at our normal police department, which wasn't
invoking
available
the
at
Fifth.
that time.
If you
Yes.
just keep
Would it
your
be fair
mouth
to say
shut,
that you were not at the normal
they
police
can
department?
continue questioning you. You're remaining
Yes,
silent,
however, with
but
the
you
audio, I
haven't
was still
invoked
trying
the
to make sure I
right
followed the policy to
remain
the best of my
silent.
ability.
Can you show proof of that policy?
I don't have it.
He doesn't have to.
So it'd be fair to say that
If you want to
there's no way to
cross-examine him
determine
on
if
the
that truly is
policy,
policy if it can't be proven.
you provide the policy to
Grounds.
prove him wrong.
Sustained. As to the
It's
following question,
argumentative.
it's argumentative.
How can that policy be proven?
It's argumentative.
Objection.
Grounds.
Sustained on relevance grounds.
They probably. Ooh. Yeah, I mean, at this point,
Do
they're
you
so
know where
far
that
in that they're
procedure is
not.
located in your
They
agency rules?
can't revoke
Objection
Grounds.
relevance.
at this
Sustained.
point, but they're
Grounds for the sustain, Your Honor?
Relevance grounds.
yeah, it's a mess.
Relevant. Not relevant. Next question.
Yeah,
This is not relevant?
keep giving her side eye. None of this has
No,
been
keep
relevant.
We can take it up later outside the presence of the jury at our afternoon break, but for now, keep going.
None of it has
I
been
follow, Your Honor. I
relevant.
apologize.
But keep giving the judge side eye.
So once the detainee was
I
taken
think
to
most
the
federal
Mosquito
judges
Police
would have
Department,
gagged him by now.
that would be a pretty standard police department. Would that be fair to say?
Standard in
Yes.
what way?
And
As in with a
a
holding
second
cell
interrogation
and an
also took
interrogation
place
cell?
at that police department, correct?
Yes.
Any reason why the first interrogation couldn't take place at the same police department that the second one took place at?
Well, the first interrogation again
Was
wasn't
at
at a
the
police
hospital.
department. Muskego was utilized as they had a lockup facility. So we interviewed you there.
How
Around what
is
time
the
was the detainee
location
taken to the
of his
Muskego Police Department?
interrogation relevant?
I don't recall the exact time.
I told
you
you,
also
this is going to
stated
take
that-
days.
Another law
Mr.
enforcement
Brooks,
officer.
I apologize for the interruption, but I just want to make sure my jury is in good shape. If you want to just take a moment to stand. It's a little slow, I think, for them, so we're just going to stand for a minute. Again, my apologies for the interruption.
How is any of this of any consequence? Unless you were interviewed hanging by your toenails above a
Anyone on my
live
jury need a break? Are we
volcano,
good? I'd like to keep going.
it
Anyone?
doesn't matter.
Okay, no response to that. They said they're good. All right, we'll sit back down. And again, my apologies, Mr. Brooks. Hopefully you know where you were.
Yeah.
He was in the mid ramble.
It was another
He's doing his
law
level
enforcement
best.
officer who actually did the transport of the
He's
detainee
doing
at
his
that time,
best to
correct?
put them to sleep.
Yes.
And you stated earlier in testimony that you and your partner followed behind that transport.
And
Is that fair to
that's
say?
the thing. He
Yes.
he throws out.
And
he's
I'm assuming
thrown
at some
out
point that you
the names of cases, even the citations of cases, but
will
he
actually
hasn't
strike that.
given the holding from those
You
cases
stated to being
or
present
applied
during the
them to
booking
this
process
case.
into the Muskego Police Department. Is that fair to say?
Yes.
So why couldn't interrogation be conducted at that time, which would have been more ideal, considering that you said
It wouldn't have
there
been
was a
more
a
ideal.
lockup. I forgot how you referred to it.
Who
but
says it would have been
basically
more
like a room
ideal?
the detainee could be secured.
Well, you had been talking about at that point when we arrived at the facility with you that you hadn't eaten all day, you hadn't slept, so we wanted to give you an opportunity to eat, sleep, clear your mind, and refresh yourself.
Ugh.
And what bearing would that have on interrogation?
Well, I mean, you said you hadn't eaten, you hadn't slept. So I think a person is more focused when they're fed and they're rested.
So they wanted
we
you
wanted to give you the opportunity
to be
And
rested and fed
in
before
your opinion,
interrogating
how
you.
would that had affected interrogation?
I'm going to excuse the jury right now. So if our jury, we could stand for the jury so I can take up a legal issue, please. All rise.
Oh. It's like I know we've mentioned him before, but you look at delete laws. He runs up to cops and starts shouting case law at them on the side of the road. It's like, so, and he'll be like, "Ooh, it's a Mississippi Supreme Court case that I'm citing outside of Mississippi." But if I say the justice's name from 100 years ago, it makes judges tremble. It's like, no, not in the slightest.
All right, thank you. Be seated. So I'm going to take up two issues right now. One is when I paused earlier and told Mr. Brooks I would allow him to, it was regarding the policies. I want to know, as the proponent of the evidence, why you think that's relevant. And then
not.
secondly, the questions I believe that you are asking related to the interrogation, unless you can convince me otherwise, go to a legal issue that this court has already determined. But I'll hear you out on that. I didn't want to make an assumption, but I also didn't want to
let
have
you
you
keep
question this
rambling.
witness about what really are legal issues that this court previously addressed
That's
regarding
it.
the admissibility of
jail
the interviews.
administration
Well, to the
is
first
not
one
relevant to the jury.
about the
The policy.
policies, that's relevant because I think
How does it go to his
it
credibility?
should be
How does it go
stated
to
for the
the
record
evidence?
why he left his phone recording after he acknowledged that the Fifth Amendment right to silence had been invoked. At that point, interrogation is supposed to stop completely.
But that doesn't mean
Well, I
recording
understand what
has
you're
to
saying From a
stop.
legal perspective, but that doesn't mean the recording had to stop in and of itself at that point. He did provide an explanation on the record.
She's so nice.
His explanation was that it's policy, right?
He answered the question, why do you believe having the specific policy and him testify about the specific
He is the
policy
foremost
relevant to his testimony?
Well, I believe that if that's in fact policy, it should be proven. It should be proven
It
that
doesn't have to be.
that's a fact.
If you
That's,
think
that
it's
is a
not
real
policy, bring the
For all we know,
actual
he could just be
policy.
saying that it's a policy.
Bring the actual policy.
And at that point, it makes him continuing to record after the Fifth Amendment had been invoked.
Well, right now, you assume facts that are not in evidence, sir. And so you're the proponent of this testimony through your cross-examination. And so without something more, sir, I don't see where there's relevance as
He
to
might
what
be
the
able to
specific
take one.
policy
He won't
is.
be able
Can you
to
see what I'm getting
understand
at,
it.
though, Your Honor? If he's saying that this is a policy of his agency, he should be able to
bring
prove that that's
evidence
policy.
that it's not.
Because at that point, if there's no way to know that that is the correct procedure that they use
Did
every
you
time,
put him on notice that
then
he
why-
needs
Again,
to
making a
bring
lot of
the policy with
generalizations
him?
that I don't think are accurate as to what he said. This is a trial, sir, where the allegations in this case are that you drove through the Christmas parade, right, and caused death and injury to a number of individuals. There's also those other charges related to the bail jumping, the battery. And frankly, his conduct isn't on trial. We're not here about a
I
police
mean-
misconduct trial. I'm not saying that some of this information might
If
not
he
be relevant
wants
to his
to
credibility, things of that nature, but you
that
have
it's
to,
not policy,
again, you're the proponent
He
of
needs to
this.
bring the policy.
Why do you believe those policies
But once
relate
again,
to an
it's
issue of
not
fact in this case, or
relevant.
otherwise go to your defense?
I believe that is relevant because it can show that at the very minimum, that first interrogation and anything related to it should not be admissible.
Other
as
than your
evidence.
name,
That's a legal determination
Did
that I've
anything come
already
out
raised. Your
of it?
attorneys represented you at that time. They made a variety of arguments. So to then make this trial about that interrogation, it's not relevant.
I'm not making the whole trial of it.
you are.
But the issues are
Making a whole
legal
trial.
issues that this jury will not be asked to answer.
Juries do not decide
I've already
legal
ruled on the
issues.
admissibility. That's a legal determination. So I'm not seeing the relevance to those specific policies, and there is simply no
This
requirement that
cross-examination
the
is going to
state
go
or this
on for the
witness has
rest
to
of the
prove
month.
those policies. You
And
are
how do we know if it's
representing
true, Your
yourself. Hold
Honor?
on, let me finish.
That's
You're
a
representing yourself.
legal
I'm not aware of any
question.
subpoena that
It's
required him
not.
to bring those policies with.
Exactly. Like I
So
said,
that would
if
have
you
been on
wanted
you
to
if you
question
felt it
him
important
about
to
the
cross-examine him
policy,
on those policies to require
you either have to
that.
take
I'm
his
not
word
aware of that.
or
Have
you
done
had
that?
to provide the policy.
Obviously, it was going to come up.
Did you issue a subpoena ducus
That
tecum
would
to
bring
this
out the
witness to
duck's
bring
tape.
with any of his policies
How
related
can
to
I do that
interrogation?
myself, Your Honor?
That's
How
a
can
you
I do that
problem.
from a jail cell?
That's
You
your
were given
problem.
all of those blank subpoena
You
copies,
fired
sir,
your attorneys
and
so
you could
the
have filled
burden
that
is
out
on
in a way
you
for this witness
to put
to
on your
require. You
defense.
didn't do
If
that.
you
So
who would
needed
have served
the
him?
witness to bring
the state
materials,
would have.
it's
They
on
served your
you.
other subpoenas. But be that as it may, that's not what we have here. So I believe that your line of questioning is on a topic that's not relevant to the issues in this case. So I'll give you one more opportunity. Why do you believe that questioning him about the policies are relevant to your case?
is relevant to the case because why would he be recording before people are even in the room
That
and
would
then
be-
after?
Well, that's argumentative, sir.
once
That
So
would be fine.
once
that's
the
not a
Fifth
legal
Amendment-
basis.
Once the Fifth Amendment is invoked,
They have to stop
interrogation is supposed to
questioning.
stop. Period. There's supposed to be no more
Recording
recording.
isn't
no more questions
interrogating.
asked. That should be the end of the whole interrogation.
Recording
These are legal
is
issues
not
that you're trying to
interrogating.
raise before
These
the
are
jury.
separate
I've already
issues.
dealt with the admissibility, so you've not provided a legal basis
And
to
besides which,
further question this officer
I
about
didn't hear
policies
him
related to
invoke his
the
Fifth
interrogation
Amendment.
and the recording. He has answered questions.
Not
I gave you
answering
some leeway
questions
on
is
that.
not positively
answers are before the
invoking the
jury.
Fifth.
Certainly, you'll be able to argue the meaning of that or the lack
You
thereof
have to
during
say,
the closing arguments.
I
if we
want
get
an
to that
attorney.
point.
You
Let's
affirmatively
move on,
state,
though, to this
I'm
issue
invoking
about
my Fifth Amendment
um,
right to remain
why
silent.
I excuse the jury.
Not answering questions isn't invoking.
And again, I believe you're questioning him about legal issues that aren't relevant, but you're the proponent. You want to question him. What's the legal basis you believe I should allow you
I
to
don't
continue
think he
with
does
that?
now.
What legal
He
basis
doesn't
are
know
you
the
referring
Sixth
to?
Amendment.
I believe you were attempting to elicit information or evidence, testimony from this witness on issues that are not relevant.
Is that referring to the same question?
Not
I
the
asked about
policies, what I
policies?
just stopped the testimony for,
Oh.
because I don't want to create issues in front of this jury related to legal
He's
issues
so
that are not before them to
tedious.
determine.
And is that referring to the question about the policies?
No. You were asking him, why did you stop? Why did you not question him further? Meaning, why did this detective not question you when you got to the Muskego Police Department? Why did they wait till the next day? I stopped because I know the law on this area, and I know that when a subject invokes their Fifth Amendment, or when you're a defendant in state, it's the 14th Amendment, but nonetheless, right? You have rights under the Wisconsin Constitution as well, but that there's
The rights
because
under
you
the
only
14th
invoked your right
Amendment
to
in
remain
state
silent.
court
They waited
because
to question you
the
until a
Fifth
sufficient
Amendment
amount of
is
time had passed. In
incorporated
addition to the other reasons,
to a right in
I'm not going to let
state
you question him in
proceedings
front of the jury
by
about that
the 14th
specific thing.
Amendment.
Or at least I'm cautioning you that I'm stopping it because I don't see where that's relevant. But if you keep pressing him on that, you're going to open up the door to him saying, because I was following the constitutional requirements and giving you a break in the questioning so that I could, get a statement I believe would be admissible later on. That's what I'm trying to avoid.
With all respect, Your Honor, I don't think he would have said that.
My concern was we were headed down that path. So if there's some
Yes.
other
So the
reason
14th,
you
the
want to
14th
question
under
him,
Amendment would have
breath
been
and
referring
interrupting
to
her.
the having the attorney present.
I'm sorry, say that again.
So you said when you stated that you know the law
The
in
Fifth
that area
Amendment is
about
incorporated
the
to
Fifth
the
Amendment and the
state
14th Amendment.
through the 14th Amendment.
What were you referring to on the 14th Amendment?
I'm not going to explain that any further, sir. Let me just ask the state if
Once again,
if they
It's
see
not
this-
her job
Attorney
to
Bailey, that's
explain
exactly
the
what I
law
was getting at.
to him.
All right, well, you understand it's my job to protect the record too. So I want to make sure that, all right, so with that understanding that you are questioning this witness about why they didn't take you to Muskego for the first interview, is that where you're wanting to go with all of this?
That was the question.
All right, well, I might have misunderstood, but in any event, gave us an opportunity to talk about the other thing, so that's okay.
So
Oh.
is that a fair question to ask then? Because I'm confused now if I'm even allowed to ask that question.
I think
You
part of the
probably
issue
shouldn't.
sometimes, sir, is sometimes the questions aren't as artfully worded as they could be. I know you're doing your best. I like to look at it this
He's
way.
verbally
Questions
illiterate.
that are a sentence at a time, meaning a thought at a
Audibly
time, because then they're not
illiterate.
compound, are the easiest for a witness to answer. And when you start bringing in other things, it can be confusing, and then
It's
I
word
might not
salad.
understand, or a party or a
Objection,
witness
word
might not
salad.
understand what you're asking. So looks like it's one of those situations where I was a bit unclear. It's been clarified. If that's the line of questioning that you are going to go, then that's fine. Then I would allow that. I'm not going to stand in the way of that. If the state objects, I'll obviously that's a different story. Then I'll have to rule on it. But I think we're all on the same page now.
And just for the record, Darrell, I will be objecting. I don't want there to be, just because I think this has been asked and answered. He was taken to Waukesha Memorial Hospital for medical clearance. They want to minimize the number of times that he's transported, and they needed the information sooner rather than later. So I will be objecting as to asked and answered. I just didn't want to, we asked the question that the court suggests, and then I object, and so I do want to put that on the record just so the court's prepared for it.
Understood.
The question of why wasn't the first interview conducted at Muskego Police Department had not been answered.
It has
I'm gonna
been
let you
over and
ask that
over
question.
and over.
So even if they object, we'll put everyone on notice.
Over and
Because
over.
I
It's been
think
asked.
it's reworded a bit differently. So I think it's fair. I'm going to let you ask that. All right. Let's bring the jury back out.
I mean, my left leg that's incinerated as medical waste, but attended 2.5 semesters of law school with me. It has more legal knowledge than he does.
I might have to get me more water too. Thank you so much.
Time to bring up subject matter jurisdiction, Brooks. The jury's on its way in. Bring up subject matter jurisdiction.
Run through this one.
All right, we'll make sure there's another one. All right, I can't see the head monitor. It's got or don't have.
Thank you.
Mhm.
They're never going to finish with this cross. Exactly. It's asinine. Even then, I think he's so illiterate.
All right, thank you, everyone. Please
couldn't.
be seated, and Mr. Brooks, you may continue with your
He couldn't
questioning
do the
of
pictures.
this witness.
And do you recall why the first interview was not conducted at Muskego Police Department?
Yeah. So in regards to the first interview at that point,
It's a cover for
as
his
I kind of
porn,
stated in my earlier testimony, we didn't know exactly where you
porn
end up.
Bible.
Muskego didn't become an option and something we thought of as a final place for you until after the first interrogation was
A
was
mute
attempted
button
and was
would
over
be
with.
better.
Uh,
Why fast
and
forward when you can move?
Do you recall if you made that
or a
determination
stop
yourself, or
button?
was it your supervisor or something of that nature?
Objection relevance.
Ground.
As to where they were going to take you?
Yes.
Overruled. The witness may answer.
I discussed it with Detective Casey.
Go ahead.
And at that time, that's when you learned that Muskego Police Station was a viable location.
Yes, that's the point at which we made the decision.
Had you ever used that police station before in any of your investigations before that evening?
Objection relevance.
Grounds.
Overruled. The witness may answer.
I had not.
The city of Muskego.
But when our department first
MOS
closed, that was given as an option for us. We
KEGO.
didn't have our own municipal.
It's another suburb of Milwaukee.
And do you recall around what time you started to conduct the second interrogation?
Yes, 12:11 p.m. on the 22nd.
So they gave you a full, like, 10, 11 hours to sleep
And
and eat, and
do you recall how that interrogation started?
it was an
Yes, I explained to
emergency.
you. I had more information about the domestic, and that's what I was looking to speak to you about.
It
Do you recall
basically
making a
circulation
statement
was
that
cut
we all
off,
know how
and
women can be? They're crazy.
I do.
And what did you mean by that?
It was just additional rapport building that I've talked about in my earlier testimony. Speaking to you on a person-to-person level, quite honestly, it wasn't a judgment I generalized towards all women in the world. It was just
it was compartment syndrome, swelling,
wanted you to
cut
feel
off the
comfortable talking to me as
circulation.
a person. I
But
felt we had rapport. I felt you were, I could tell
I
right
wasn't
before
paying
you were
attention.
comfortable
I
speaking to
had
me.
my feet up on the
And it was just a
ottoman and
continuation of
didn't
that.
move for a long time, and
So it'd be fair to say
the
that
tingling went away, so I didn't notice it.
that
And by the time I stood
comment
up,
doesn't reflect your
it
opinion
was
of women.
done.
Correct.
Why did you feel that that would have been necessary to build a report that you stated that you already felt that you had?
Welcome back. Good morning.
Because it was just being relaxed. I was relaxed. I didn't want to make you feel unnecessarily nervous. We had been, talking to each other in the casual conversation from the night before, very civilly, very openly about non-custodial topics. And I was just continuing to go along those lines. It wasn't anything other than to just communicate with you on a I guess, stiff level, relaxed level.
And do you feel, would it be fair to say that
From what I can tell, he's a
other
very good
comments could
cop.
have been used to keep the detainee at ease?
Objection, vague.
Grounds.
Sustained as to the form of the question.
Was there any other conversational tools you could have used to keep the detainee at ease?
Objection, same.
Grounds.
Overruled. The witness may answer.
There's
Perhaps,
plenty
maybe.
of strategies they could have used. They chose that one.
So it'd be fair to say for the situation, you felt that the conversational tool you used would be more appropriate at that time?
That's why he used
So
it.
ask that one more time, please.
You felt that, would it be fair to say that you felt that at that time, the conversational tool that you use would be more appropriate for the situation?
I don't know that I was really thinking about appropriateness. Like I said, I was just conversing you on a normal person-to-person level was my intention at the time.
So it would be fair to say that you assume that would put the detainee more at ease by starting the conversation with
Cares.
along those lines?
I wanted you to be relaxed. That's not anything that I did just specifically for you, Mr. Brooks. I always want
Gotta
people
get the
to
name
be
in there.
as relaxed as they can be. I want them to feel comfortable to talk to me if they are willing. It doesn't change the fact that ultimately I have to read Miranda. But I always want all the people I talk to feel comfortable and be willing and know that they can talk to me if they want to.
Speaking of Miranda, do you recall reading the Miranda rights in the second
We
interrogation?
heard you.
Yes, I do.
Do you
Have
recall
them read to you.
how long into the interrogation before you read the Miranda rights?
Objection.
Grounds.
Objection, misstatement,
Grounds.
and mischaracterization of the
The
evidence.
interrogation had not started yet.
Sustained as to the form of the question.
it would be fair to say that the second interrogation was pretty long.
That
Would that be fair to
sucks.
say?
Yes, sir.
I think
Do you recall when in the second interrogation you read the Miranda rights?
the medical
I'm going to object again
profession
to the form of the question.
Right.
is
The interrogation
too slow
began,
to
the court made a
amputate
finding as to
much
when
of
the
the
interrogation
time.
began.
That they have a
prior.
save it at all costs attitude, even
I'm gonna
though
sustain the objection.
with the
It's
state
form
of
the question
prosthetics these days,
calls for a legal conclusion.
you're better off getting
Next
getting
question.
rid of
Did
what
you
doesn't
immediately
work or what's
start the
causing
second
pain.
interrogation with the reading of Miranda rights?
I mean, I knew the writing was on the wall,
No, that is not the first thing I
So,
stated to you. First, I explained to you
I checked in and said, cut the
what we
damn
were,
thing
what I was
off,
wishing to talk to you.
because I knew if
And do you
they
recall how
attempted
long
to save
you
it,
were in that explanation
I'd
phase
be
of the
left
interrogation?
with something worse than
Maybe
what a
around 15
prosthetist
minutes,
could give
16
me.
minutes.
So
it'd be fair to say that you didn't read the Miranda rights till
I
somewhere
checked into
after
the emergency
already
room
interrogating the detainee for
telling
15
them
minutes at
to
least.
amputate, but it was an
Grounds.
emergency.
Misstatement.
Sustained. Calls for a legal conclusion. Mistakes.
Of course, it took 12 hours
Testimony as well.
before they took me
You
in
read the
for
Mir-
surgery,
You read the Miranda rights after
and the last couple
15
hours
minutes.
I was begging them to hurry up and get it off of
Yes,
me.
thereabouts.
It was gruesome. It was
Do you
hurting.
recall why you didn't start the second interrogation with the Miranda rights?
He did.
I'm not required to read them immediately. So those first 15 minutes were verifying your personal information.
It's not
explaining
interrogation
that
yet.
I now wish to talk to you about a domestic involving your
Talking
girlfriend.
is not
And then I
necessarily
read them before asking you
interrogation.
any specific questions about that event.
Would it be fair to say that you had already obtained personal information the night before?
I mean, to me, like I've said,
I had, but I didn't have it in front of
I-
me, and I have to recomplete the whole Miranda sheet. So
I
had
think
to
it's
refill
cool
out the
having a
top
robot
form of the
leg.
sheet, which is your name. So I had to verify.
It's cool.
So it'd be fair to say that you
I'm a
had
cyborg.
obtained personal information that you didn't bring with you for the second
It doesn't
interrogation?
bother me in the slightest. I realize
I did not have your
I'm weird.
information written down at that point.
I didn't spend a
Yes.
minute
Do you
mourning the
recall
leg.
why
I
At
said
that
good
time,
riddance
you
and
didn't have
moved
the
on.
personal information that you had already obtained?
No,
I mean,
No,
I
as
wish I
in-
didn't have the phantom
I don't
pain.
recall why I didn't have it.
That sucks. But other than that, it's never bothered me. I mean,
And you said
it
you
happened
started
during
off
law school. I was
second
back in
interview with,
school 3 weeks later.
information about
It's-
domestic allegations. That'd be fair to say?
It just
Yes, after reading
it was never a big
Miranda,
deal
if that's
to
what
me.
you're asking.
No, I
You're
didn't.
right. I don't know what are you asking then? Just so I'm clear.
The question was
Exactly. His Miranda
Again,
rights were not
started
violated.
off second interrogation with domestic allegations.
Yes, that was part of the beginning, explaining to you those allegations that had come forward.
Any
Things I
re-
didn't know about the night before.
Any reason why you wouldn't explain the real reason why the detainee was being detained?
It was the real reason.
At that point, the domestic was part of the real reason why you were being held in
It
custody.
still is. You're charged with it.
Did you
You're
have any
still
more
facing
knowledge
legal
about
peril
The
for it.
incident from the previous night at that time?
Are you referencing the parade aspect of it?
Yes.
At that point, yes, I did.
Not knowing the extent.
And why wasn't that information
it's
given
very
to the detainee
possible.
at that time?
It's if you're in pain.
As I explained in my earlier
left with
testimony,
the hand
the
not working,
idea behind the second interrogation was I
it's
began with
cruel
the
to make you
domestic
keep
abuse
it.
issues.
I think.
Questioned you about those, and then moved into the parade aspect of the investigation.
And Why not start with all the information you knew?
Objection relevance.
Grounds.
Argumentative.
Overruled. The witness may answer.
Can you repeat the question, sir?
Why would you not start the second interrogation with the information that you knew
In regards to the parade?
in regards to all the information that you had at the time?
Well, as I
You
stated
want
again in
him
my
to
earlier
vomit
testimony,
everything out at once?
as we began the second interrogation, I explained it was about a domestic with your girlfriend, Erica Patterson.
And that was part of it. It still is.
But again, I can't give you all the details because part of gauging truthfulness and avoiding I'm not leading you is not telling you every single thing. I had told you she alleged there were physical injuries, but I can't really tell you what they were because I want to see if you're going to be honest and tell me what they were. Additionally, telling you what the injuries were as far as Mr. Patterson could cause you to create a lie to avoid those. And it's the same issue with the parade.
Did you speak to the complainant of the domestic allegations at that time?
Objection. The use of the word complainant.
Sustained as to the form of the question.
Had you spoken with Ms. Patterson about the alleged domestic allegations?
I did not.
He doesn't have to
So it'd be
conduct
fair to
the
say that
entire
you,
investigation
at that time,
himself.
didn't know if they were true or not.
No, that wouldn't be fair to say.
It's for the
And why would
jury
that not be fair to
to
say?
decide if it's true or
Well,
not.
hold on. It's for this jury to determine the facts of this case, including the domestic allegations. So I'm not going to let a witness comment on his belief or not on any other witness's testimony or information. Fair enough?
I apologize.
All right. Next question.
Had you at any time before the second interrogation spoke with Ms. Patterson?
No.
He didn't have to. It's a team effort.
You made reference, I believe it was in both interrogations, to reading. It was in reference to the Miranda rights, stating that if I was at home on my couch, do you recall making that statement?
What?
Yes.
And what do you mean by that? At home on my couch. What do you mean by that?
Well, Miranda is strictly custody based. So I could interrogate you or question you about a matter in which you were a suspect at your
Explaining
home.
the law
I would
to
not be
him.
required to read those warnings. Being we were in custody, we were at the Mesquite Police
Once
Department.
again,
You've been handcuffed
Miranda
and transported.
applies in
Custody was
custodial
obvious and required by
interrogation.
law, therefore, to read
If
those
you are
rights
not free
based
to
on
go
you being in custody.
and they are asking you questions, Miranda applies.
You made a reference to that. That's a requirement by law. In custody, you have to read those by law.
Yes. This
Relevance for this hearing.
is so irrelevant.
I'm going to sustain that objection. I believe it's also been answered. So next question.
It's a legal determination. The judge has
Do
already
you
made
recall
that
if
legal
those
determination.
Miranda readings are to be at the beginning of the interrogation?
Once again, that's a legal determination.
Asked and answered as well.
Sustained. It has. It also calls for a legal conclusion, which
No, they
is
are
not
not.
appropriate.
It's a
Next
legal. The judge decides the law. The jury decides the fact. Whether or not a Miranda
In
applies
the first
when
interrogation,
is a
you
legal
spoke of
question.
the detainee being detained for loitering and prowling. Did you make reference to that in the second interrogation?
Who
No, I did not.
cares?
Any reason why?
Because they had a better idea what
By the
was
time of
going
the
on.
second interrogation, the primary focus had shifted to the domestic incident between yourself and Erica Patterson, and
And the parade
also the
massacre.
parade, because by this point I had more information about the parade and that incident
It's
specifically.
almost like
So what happened
as
to
you
the
gain
initial loitering and
information,
prowling
you
allegations?
narrow
Why
the
were they
focus
discarded?
of your investigation.
At that point, they were not the primary concern. Eventually, the interrogation came to a stalemate, so to speak, and we didn't discuss it. The primary concern was the domestic issue between you and Ms. Patterson, which at the time I began to start the first interrogation, I didn't know anything about. And then the fact I now had more knowledge on the parade.
So do you recall who made the decision for the loitering and prowling allegations to be discarded?
Your Honor,
It-
I think that
that's asked and
objection,
answered
mischaracterization of the testimony, the fact that it wasn't charged
is
isn't on this
irrelevant.
officer.
I didn't say anything about it being
Since that's
charged.
not an evidence for the other reasons indicated by the state, I'll sustain the objection.
Just for the record, I didn't say anything about it being charged.
Understood. My ruling stands, even with
It's
that.
still irrelevant.
So would it be fair to say that in both interrogations, you gave different reasons why the detainee was being detained?
Who cares?
The explanations that I explained to you did change. However, again, the domestic was not
You
known
mean
at the time.
grounds?
So that
No
circumstance
deed.
changed a bit. That became something that was of importance to us. Domestic abuse is taken seriously. And again, there was more knowledge about the parade.
Would it be fair to say that
No.
because of the change in information between the first interrogation and the second
It's not a
interrogation that
change in information. It's additional
that can be
information.
misleading?
Misleading to who?
Objection calls for speculation from whose perspective?
Grounds.
Sustained it as to the form of the question.
There you go. He said grounds twice. Make up for last time.
Is it fair to say that someone who is being detained would perceive that as being misleading when there's two different reasons why they're being detained that was told to them?
Once again,
Objection,
speculation.
speculation. This witness cannot know what is in someone else's mind.
Calls for speculation.
I'm calling for laser eyes. Aimed at Brooks.
At any point in the interrogations, did you knowingly lie about the information that you had?
There was information I withheld from you, yes.
But that's not lying. That's just
So
not
it'd be fair to say that you
saying
lied.
everything.
Objection mischaracterizes this
Right.
officer's answer.
It's argumentative, sustained as to the form of the question.
Just for the record, there is a point in there where you
Sustained as
Stated
to
that
the
he
form of the
lied.
question.
Stop testifying.
why did you continue to withhold information repeatedly?
Because he's interrogating you, you potato.
I guess at which point? Through the whole, are we talking about in the middle of the second interrogation at this point? What
Do both
point are we talking about?
interrogations. Do both of them.
Well, there really wasn't a first one, because when I got interrogation doesn't truly begin until I'm asking you incriminating questions potentially.
Which
after
he
you
wasn't
agreed
asking at the
to
hospital
waive your right
anyway.
to speak, something you didn't
His
do
name
on,
isn't
on the first day.
incriminating.
On the second one, quite honestly, it goes back to what I've stated in my earlier testimony. I wanted to make sure the information I was getting from you was truthful. I wanted to make sure that I didn't lead you down a path of potential lies. And third, quite frankly, Mr. Brooks, I didn't believe if I gave you the information, you were going to tell me anything.
You made reference to the first interrogation saying that there was no
No.
waiver of that interrogation.
Objection.
Because once again,
I'm
he
referring to what he just said at
it
the
was
beginning of the
he
answer.
could have been
I'm going to
arrested for
sustain the
fouling.
objection. Next question.
Grounds for the sustain.
They just don't have to continue with it. If they have
Next
other
question.
things to charge him with, charge.
Grounds for the sustain, Your Honor.
Okay. Before I
Next
leave the
question.
sustain, I'm going
Can't
to
get no grounds.
to
Okay.
take a quick break. But when the court calls for a break, I will just fast forward. So I'll be right back. I'm back. He was whining about sustain.
So you made reference to not being sure if you would. I'm trying to remember exactly what you said. You wasn't sure if you were going to get the information you were seeking.
It's fine. There's
Correct.
And is that what led you to lie about the
he
information you knew?
didn't lie.
Mischaracterizes the testimony.
Grounds.
It's argumentative, sustained.
Not giving all the
Did that
information
lead you to
at once isn't lying.
not be forthright about the information you knew?
Argumentative.
Sustained is to the form of the question. His words were that he withheld. You may
That led you to withhold information that you
Withheld.
had obtained?
I'm sorry, did what part with all that? Can you restart the question?
Yeah, right.
Because you were not sure if you were going to get the information you were seeking, that led you to withhold information that you had obtained.
Well, again, as I've stated in prior testimony,
It's all strategy. It's
strong
chess.
part of the reason
It's
I withheld
poker.
information is I wanted to gauge how honest and truthful you would be. I think it's important to know you lied to me, and this was proven by evidence about your mother owning a vehicle. You know, you lied about coming out here in a tan possible
This
Kia.
is good.
So there were lies that were told at this point. You lied about being body slammed by officers. That was later
Cops
proven to
can
be
lie.
advise the jury of a
interrogation.
couple different things at this point. Obviously, ultimately, the juror will determine the credibility of all witnesses and the weight of the testimony to give for any witness. So whatever any person's opinion about the testimony or previous statements or information from another individual, I'm telling you, is not evidence. You need to determine for yourselves what the facts are in this
Exactly,
case.
Steve.
The other thing I want to remind the jury of is that an accused has the right to remain silent, and when that silence cannot be used against him, since there was a comment earlier. To the extent that it was commented on, I'm going to instruct the jury to disregard that as well. Go ahead.
I'm sorry, continuing. So it just was
Hold on,
that.
It's narrative at this point. He's going to ask his next question.
Okay.
If the state needs to redirect, they will.
You made reference to, well, let me back up from there. Is it standard practice in your agency to withhold information?
Yes. Yes.
And in
Yes. If strategy calls for it, yes.
Oftentimes there's information that I won't tell a suspect unless
Okay. I went blank
it's
for
something where I've actually
second.
caught the suspect in the act. And
I-
we go
Looks like I lost connection for a minute, so hopefully I'm back. Um, I don't want to rewind and find where I was. Basically, what you missed was he asked, axed. You had another person in the in the interrogation. Would he have asked the same questions as you did, which was objected to as speculation? So, am I am I still not live? Hmm. Let's see. Okay, I am. Okay, I in that case, I was just recapping. Um, okay, yeah. So I had it on my phone, but it was paused on there. So okay. Um, but yeah, I was just recapping because I didn't want to rewind. He's just saying he was calling for speculation about what his partner would have done in an interrogation. So with that, the killed my stream for a minute, but the video kept playing because it had preloaded because we're a little behind.
You made reference to the suspect's
To your
family. Specifically, I'm referring to the children. How were you able to come into the knowledge of the suspect's children?
detective work.
I believe I asked you about him.
Asked you.
I'm referring specifically to where they lived at the time of the incident.
That was information that came afterwards. Well, actually, I don't recall. I don't remember if you told me specifically where your older daughter lived that day or not.
He said in the interrogation
Be fair to
that
say
they
we saw
spent the second half of the week with him, but that he found out later
a
on
lot of the second interrogation. Would that be fair to say?
that they did not, and that
Portions
the
of
older
it.
daughter lives in
Yeah,
Atlanta.
portions of it, but a lot of it.
I don't know exactly how much we watched. That's really, I guess it depends on your
At,
definition of a lot.
at any time, do you recall it being stated where the defendant's children lived?
He found out later. Who cares?
Not that I can recollect watching today.
I do.
Had you seen that video
I
before
remember.
today?
You
Yes.
The second
lied
interrogation?
and
Yes.
said they live with you part-time. But
Have you seen it
the
in
older
its
daughter
entirety?
lives in Georgia. The younger daughter
Yes.
lives in Iowa. The son lives somewhere else because he's 18. Once again, he's calling into the jury's attention his lies.
Do you recall? Well, scratch that.
His own lies. Because he is a liar. He's a dumb liar. A
In
murdering
reference
liar.
to the second interrogation, in reference to finding the phone, did you ever find the phone of the detainee?
They did.
You're asking if I personally did?
Yes.
I didn't know.
Do you recall where the phone was recovered?
In your vehicle.
When you say your vehicle, who are you referring to?
You.
Your mother's red Ford Escape that you were driving that day.
So it'd be fair to say it wasn't my vehicle, as you stated.
It was the vehicle
Wow.
you were
Sustained is
driving.
the form of the question.
And what was obtained from that phone, if you recall?
I don't recall.
Oh, come on.
Do you recall asking for the code to get into the phone?
Clearly his mom did it. And I seem to have froze for a second. I think I'm still here. I heard and paused it, though. But if it was frozen, he asked if anything was obtained off of the phone. So,
Phone?
Yes, sir, I do.
At any time did you learn at any time if the phone was able to be opened up?
I don't know if it was or not.
I mean, you did give the 7 pattern to unlock
So
the
what would be
phone.
your reason to ask about the phone code if you didn't intend to open it up?
Objection
He
mischaracterizes
didn't
the
say
testimony.
he didn't intend to open it.
Sustained is to the form of the question.
Did you yourself intend to inspect the phone?
He intended
No.
to have the cyber team inspect the phone.
So why would you ask for the code?
Well, because for the purpose of the investigation, we have people that are trained in doing that types of thing, getting into the phone, downloading the
He
digital
would
evidence.
not have been the
if they're
one
able.
to examine the
So
phone.
having the code would assist them in being able to do that when that time came.
And do you recall if it was more than one phone that you were attempting to access?
Yes,
Did you ask for the code for, well, back up. How many phones were you seeking to gain access to?
I believe it was 2.
And do you recall asking for the code for the second phone?
Yes.
Did you inspect the second phone?
He
Me
wouldn't have.
personally?
Yes.
No.
You can call the person who inspected the phone as a witness. Oh, wait. They probably aren't on your witness list, so
And from your recollection, what would be the significance of the phones at that point in the investigation?
Well, it's really this digital evidence that could be inside. So as it pertains to
location
domestic
evidence, phone
abuse,
call
it's not
evidence.
known if there's going to be any phone calls between yourself and Ms. Patterson. Some of the data, location data can be relevant, although you were arrested in Waukesha. It still helps to show that data as well. So
That you drove
things of
down
that
Main
nature.
Street at a certain time.
We really don't know what could or could not help us until we try to see what's in there.
judge said she wanted to end at 4:30 today. It's not gonna happen. It's not gonna happen.
At any time during the first night that you were with the detainee and during the second day, which would primarily be the second interrogation, do you recall there being any drugs and alcohol in
Were you
related to the detainee?
charged with drugs and alcohol?
As in whether you were under the influence?
Yes.
No, you were not.
But you also weren't charged with that.
And do you know that to be fact?
There were no signs of impairment that I observed.
Did you smell any alcohol?
Were you charged
No, sir.
with
Did you smell
alcohol?
any drugs?
So you're calling
sir.
to attention that you were stone cold sober driving through the parade. Good job.
Did you find any alcohol or drugs?
No, sir.
This is a great line of questioning. Good job. You were sober driving through the parade. You weren't impaired.
And during both those days, that the night of the first interrogation and the time spent during the second interrogation, someone was always with you when you had contact with the detainee. Would that be fair to say? Meaning you never had interactions with the detainee
With
strictly by yourself.
you mean?
Not that I recall.
So it was always you and someone else.
As far as he
believe so.
recalls. You don't need to keep asking the same question as a follow-up. It wastes
But
time.
you were always with your partner, though, correct?
He said
Well,
he was
he may
always
have used
with
the
someone
bathroom at a
as
point.
far
I
as
don't
he
remember. If I
remembers.
was ever alone, it was very short.
But from the best of your recollection, you were just never, for a period of time,
He said no, he doesn't
just by
remember
yourself
being
with the detainee.
alone.
The second day before transport, there was a period of time when Detective Stern stepped out of that interview room at Muskego.
But he probably still
Yeah, I
had
don't
it
know how long
on
it was just you and I
monitor
in the room,
outside the
but that's
room.
all I recall.
But even still, it was
But
all on
nothing
video.
extended from your recollection.
No.
I mean, it's all on video. How does it matter? I mean, is it like your partner stepped out of the room and you beat me into confessing? Where's the video?
And was it your belief at the time that you were set to conduct the second interrogation that you believed that without the FBI present, the detainee would likely be more willing to speak with you?
Who cares?
Speculation.
Grounds.
I'm sorry, can you repeat that again?
Was it your belief that the second interrogation without the FBI's presence, was it your belief that the detainee would be more likely to speak with you at that time?
Who
He may answer. Go ahead.
cares?
Yes.
And do you recall how you came to that determination?
Because you made a big deal about the FBI the night
Yes,
before.
it was a sense of how I felt you interacted with me, the night before. As I stated with you, or stated in testimony, we had casual conversations. Part of those casual conversations were talking about sports you played, sports you enjoyed, the Packer game that day. You seemed very calm, very relaxed. You are, and you know what you're doing right now.
Did we just
Would it be
skip
fair to say
forward?
that you can't say for sure
No.
how I'm feeling at this moment?
Not the question that was asked and argumentative.
Sustained as to the form of the question.
Would it be fair to say that at the time of that first interrogation, you weren't sure how I was feeling?
Who cares?
I guess I can't get in your head, but you presented
One
yourself
way or
as being
another,
very calm
he's
and very
guessing
confident.
how you're feeling. He can't testify for sure how you're feeling, only how he perceives it.
Based on your observation.
Correct.
Based on drilling through the thick skull of yours.
Do you yourself have any training in psychology?
Is he acting as a
No, sir.
psychologist? You're the one trying to elicit testimony from him about your feelings, about how he perceives you to have been feeling. You're the one asking.
And there was a point in the second interrogation when you were attempting to show the detainee a video.
Of you driving through the Waukesha South
Almost as if you was forcing it
marching
in his
band.
face. What were you attempting to show the detainee?
You driving through
I was
the
attempting
marching
to show
band.
you a video of when you drove your vehicle through the parade route.
Through the marching band.
Any reason why you were being so forceful in trying to do that?
Well, I felt it was
Are
very
you?
important for
Is
you
there
to
a reason
see
why you're calling it to the
the
jury's
damage
attention again? That
that was
there's
caused
video?
from the incident. And Detective Stern made the statement as well. You were asking for
Well,
more information.
You
so we
get to
attempted show
go
you
through
more
my
information.
technical difficulties.
Would it be fair to say that the question of asking for more information was asked even on the first night during the first interrogation?
Who cares?
Yes. Yes.
He's so aggravating. I mean, unless there's blatant misconduct, I'm not going to question how they do their interrogation. I'm going to try to poke holes in their case. This isn't poking holes in the case. This isn't impacting his credibility one iota.
Do you recall making a report of the night that, let me back up. Do you recall writing a report of your interactions with the detainee on the first night and the second morning?
Does this mean he's getting to his sovereign citizen nonsense?
Yes.
Are we almost over?
And did you write the report yourself?
He would write his own report.
So how it's done is I dictate it and then it is typed by someone else.
Oh, well, never mind.
What do you mean by dictated?
So there's a phone system
Means
that I talk into
he
and it's
whips it
recorded,
out
and
and
then it's later typed.
Do you recall who types it?
One of our clerical staff, I don't know specifically who it was.
someone who is paid
So
a
you made
lower
reference to a
hourly
phone, you
wage than
gestured with your
him.
right hand and made a phone.
He didn't
I
say
guess
with his
symbol.
right hand. Said he
So I'm
dictated it.
assuming that
Audio dictation.
that records what's being said. That'd be fair to say.
That's what dictation
Yes,
is.
when I'm speaking into the phone.
How can Can
And at
someone
that
go
time,
through life
speaking into
being
the
such a
phone,
moron?
were you stating verbatim? Was it off the top of your head what you remember, or did you?
It,
I guess what I'm saying is, did you speak into that phone based on a report that you had already previously written or had obtained?
has the report come into evidence?
Well, I guess I want
Does
to
it
make sure I
matter if
understand the
it's
question.
verbatim at this point?
Could you ask it again so I understand?
I can.
He-
I guess I can. I can. I guess I can be more clear.
Yeah, you
Um,
can be way more clear.
I guess what I'm trying to say is, like, by speaking into this phone, um, would that have been what you recalled at the time, or would it been based on a report that was already written by you or someone else?
He didn't write a report already.
Okay. There was no prior
Reports
report,
on
so that
reports.
what I speak into that phone and what is typed is my
Reportception.
best recollection of the events at that time.
But that's what it would have been if he had
Yeah,
sat down to type it up.
I knew what I was trying to say. I just couldn't.
Stop with the commentary.
So at that time, when you spoke into the phone, you hadn't yet filed your report at that time.
He didn't have a report
Correct. As
yet.
I'm talking, I'm completing it. So it goes into a recording and then it's later typed.
And then is it filed after being typed?
Filed.
Yeah, eventually
What do you
it's
mean
sent to court.
filed?
Do you recall if that was? I'm guessing that would be the night of the second interview, or sometime after that.
Yes, it was the night of the second, after that interview had been completed.
It certainly wasn't before it.
After that second interrogation, had you learned any more information additionally that you didn't have
Lots.
during the first and second interrogations?
Yes.
And did you put that
Information
into your
was
report?
coming in for weeks.
I believe I did, if it's the one thing I'm thinking of, yes.
Ooh, what's that one thing you're thinking of?
Do you recall how many reports you filed in relation to this incident?
He's going to be doing it till Christmas.
I think 4, maybe 5.
Why so many?
Because it's
Well,
a big case.
You know, you have to understand that after the second interrogation, the investigation wasn't simply complete. There were additional things that need to be done.
Once
additional
again,
things
he's
I
just
assisted
calling
with that
it
led
into
to other supplements being done.
attention. It's a huge case. It's not
And do you
all
recall?
wrapped up in a bow after 10 hours.
Let me back up a minute. You said 4 or 5 reports.
I believe so. I don't know the exact number.
Do you recall when the last one was completed?
I believe in June.
Why so late?
And would the June report contain additional information that you didn't have in November of 2021?
That's probably why he made another report. He had new
I
information.
don't recall either that or clarification. I'd have to see the report, I guess, to know exactly what you were driving at.
You don't recall what you
What
reported?
he was driving at was the dancing
exactly.
grannies.
Do you recall what you reported in the second report?
Not exactly. No, I believe. I don't want to speculate.
It's almost like there's a lot of information.
So it'd be fair to say you don't recall which you reported in any report except for the first.
No, that's mischaracterizing.
That is the one that is most clear because it was
It's
such a substantial piece of
mischaracterizing.
what I did.
He remembers what he
And that was
reported.
the one when
He
you
just
spoke
doesn't
into
remember which reports
phone
they're in
that was
necessarily.
recorded and then typed.
Well, they were all done the same way.
All reports are done the same way.
By him. His time's valuable. It's faster for him to dictate and then have clerical staff type it. He's a clown.
And do you recall coming to the Waukesha County Jail to serve any warrants in relation to this incident?
Yes, I do.
Do you remember what they were for?
Yes, it was a search warrant for your jail property.
Ooh.
And do you recall what that jail property was?
Property that would have been turned over to the custody of jail when at the time that you were. So personal belongings.
So probably
And what
car
what
key,
personal
the
belongings refer to exactly?
cards, the hoodie.
Are you asking? It could be anything.
Red
Anything you had
shirt,
with
the
you. Are you
jeans.
specifically wanting to know what I seized?
Yes.
Your red T-shirt.
Hey,
You were
I
wearing-
guessed it.
On the 21st and 22nd of November, the blue jeans as well as socks.
And
Imagine
do you
that.
recall why you needed to seize the clothing?
Because it's evidence. It's what you were
Yes, the
wearing when you
determination was
committed a
made
crime.
to go back and seize the clothes as it's the items you were wearing during the event. The parade event
And
is what I mean by event.
would that be the only reason why you needed to seize the clothing?
Yes, because it's evidence.
There was also possible DNA evidence, but I do not know how that came
Since
back.
since your windows were down,
Did-
there could have
did you
been
yourself
blood
inspect
spatter
the
on
clothing?
them.
I just retrieved it from the property, put it in a bag, and brought it back to the police department.
Do you recall if you seized anything else besides the clothing?
Not from your property at the jail, I didn't.
And do you recall if that was the only time you came to the Waukesha County Jail to serve a warrant?
On you?
Correct. That's the only time I recall.
Do you recall when that was?
November 30th, 2021.
So roughly about a week after the incident.
9 days.
9 days.
I could give this detective's testimony for him.
And you made reference to bringing it back to the department. Did you learn who would be expecting the clothing?
A crime scene technician, an
No, I
evidence
believe it
technician,
would have gone out to the state crime lab.
state crime lab.
Did you obtain any additional information from the state crime lab?
I don't believe I received any information from the state crime lab personally.
You can subpoena the state crime lab if they're on your witness list. Ask them if they found anything. Because once again, it was a team effort. This detective doesn't know everything
I'm going to
about
go
the
back
case.
a little bit.
He conducted the
specifically to,
interrogations primarily.
the night of their arrest. When did you arrive on scene to Elizabeth Street?
Shortly after you had been taken into custody.
I love it. You. Who's
When you arrived, what did you see?
Can't recall
clown
exactly.
in
I
a
believe
cop
you were
car.
already in the back seat of a squad car.
So at that time, suspect was already detained.
Yes, you were.
You were detained.
Suspect
You.
already
Suspect
detained.
is you, Darrell Brooks.
Can you strike that last comment?
That was his response. He will stand.
And did you do any search of the area at that time?
I love how he
I did not.
protests, and that just draws more attention to the positive ID.
What did you do from that point?
At that point, myself and Detective Stern were assigned to follow Specialist Mark Howard, whose vehicle you were ultimately placed in, and follow him to our substation where you were taken.
Where
Do
you
recall-
were taken.
Well, let me back up. Do you recall seeing a lot of different law enforcement there from different jurisdictions?
There were.
Yes, I do.
And
She's gonna call it to attention again. It was a
what
massive.
else do you recall about the scene
Incident,
as far
a
as
massive
law enforcement
scene.
personnel?
That's vague.
Basically, just that they were there.
I mean
Do you
that's so
recall
vague.
any weapons being drawn at that point, or
By then you were in custody. Why would they have?
I did not see any
They
officers
they might have still had their
with
shotguns
weapons
or
drawn
rifles, but
when I
like
arrived.
the
There were officers
assistant
with
chief
rifles
from another
across their
jurisdiction we
chests, but
heard
they were
about,
not
she'd have
pointing
holstered
them at
her
anyone.
handgun by then.
any distinct vehicles to your recollection utilized by law enforcement?
An Abrams
Just squad
tank.
cars, marked squad cars that I recall.
Oh,
Do you recall seeing a vehicle that was more like a ground rover type vehicle?
Ground Rover.
No, sir, I don't.
What's a Ground Rover type vehicle?
And so once you came to the scene, learned that the suspect was in custody, you followed the other officer to the
To
I'm guessing
the
police station or whatever it was.
The substation.
Substation. I'm sorry. Substation.
Yes.
And what information did you have at that time in regards to the investigation?
I think they're still going live.
The information again was still very limited. That you'd been loitering in the area, would receive calls, and that you were identified as a possible suspect that was in the vehicle.
Did you yourself receive those calls or any of those calls?
You mean as in like the phone calls?
This cross
Yeah.
is never going to end,
In reference
but
to
it's
the,
also never going to
loitering.
go anywhere.
No, those went into dispatch and then they were broadcast over the police radio, which I heard.
And did you immediately respond to that radio
Did you
call?
espond?
Yes, I made my way to that area.
Espond.
The area of Elizabeth Street.
Yes, sir.
Do you recall what time that was?
5:40.
It was right around, took place over a few minutes. 5:30, 5:35, getting a little after 5:30.
And what time did you arrive to the scene?
I don't know the exact time.
5:47 and 10 seconds.
I want to go back to the phone really quick in reference to the phone. In the exhibit that we were shown, you made reference to not wanting someone else to claim the phone. Do you recall saying that?
Huh?
Yes.
What reason would someone else claim a phone that isn't theirs?
Could be their own reasons. One thing we have to do once we have possession of property
It's
we have
secure.
to make sure
You have to
that we
secure the
release it to the
property.
appropriate person. So that would be important.
Is it fair to say that
No.
all property obtained from a detainee is sealed?
Sealed.
I guess, what do you mean by sealed?
Like placed in a sealed bag,
It,
pursuant to whoever's the property belongs to?
it would be placed
It's
into evidence.
Typically, we would take property and probably put it in a paper or plastic bag. We don't necessarily seal it and then place it in a locker.
Would you write on the bag who the property belongs to?
Yeah.
Well, if it's personal property and it's going to be returned, it would go in a locker
They would put the case
Typically-
number.
that's associated with their cell. But if it's evidence, it would go, to a different place. It depends on the type of property you're talking about.
Would
It would be marked, though,
be
as being
some type
evidence
of
for the case.
identifying
They just throw everything
Something
into
to
a common
identify the
box
property
and
to the-
randomly.
the owner of the property?
Yes.
When you came to the Waukesha County Jail to serve the warrant for the clothing or personal property, as you stated it, was that property sealed?
It was in a secure room.
Was it sealed?
Like the bag it was in, no.
The bag was just wide open?
I don't recall if it was
He
wide
didn't
open.
say
They have it
wide
in a
open.
property bag that
He said it wasn't sealed.
I don't remember the exact conditions of it.
Did it have any identifying name on it, or
They just
birthday
grabbed a
or-
random bag.
They utilized a system in which they looked up your name and the bag had a number. The number was associated to your name. So they were able to find it that way. And then, once I got in the bag, I recognized the clothing as your clothing.
so it'd be pretty fair to say that the system that they use is pretty easy to identify what property belongs to whom?
Yeah.
It seemed to be. To get the specifics on it, you'd have to ask them, but they looked up your name, hit a number, and your bag came right across.
Imagine that.
Does your agency use a similar method?
No.
And what method does your agency use to
Irrelevant.
identify property?
My
Irrelevant.
agency would simply, we're not a large county jail, so we only hold about 5-6 people at a time. We would take personal property, put it in a paper bag, put that paper bag in a locker
This is
that typically would
irrelevant
correspond with the cell number that you were
unless-
placed in. And then your property would also be
He
documented.
has
on an
evidence they
electronic
retrieved this
so we knew
way.
it belonged to you.
You made reference to not being a
And even
large
then,
county jail.
It's mostly
Are you
inconsequential.
referring to the holding station?
The police precinct. A
Our
police
standard department,
a
that we're
police
back in now, is a
department-
municipal lockup.
lockup
It's very small.
is
So it'd be
much
the holding
smaller
station.
than a county jail.
They call it the police station.
You
the
hold
booking room.
people in the
Police
drunk
station,
tank
substation, holding
overnight,
station.
or
Correct.
you're not holding people for a year awaiting trial in the police station. It's killing me.
At any time during the second interrogation, were there any other law enforcement watching the interrogation from another location?
Probably
Yes, there were.
Can you explain why?
because it's a team effort.
Well, again, the FBI was present in a different room because we still did not know whether there was a terrorist nexus to this incident at that point.
Can you explain what a
Is
nexus
that the
is?
only other law enforcement that was watching the interrogation?
There may have been some of our own officers. I don't know how, if they were moving around the building or I don't know what they were doing.
So it'd be fair to say you can't recall if there were-
Correct.
I think in real time they're actually done.
if at that time there was still uncertainty about the nature of the incident to the point that the FBI still were kind of involved at that point, any reason why they wouldn't accompany you and your partner for the second interrogation as they did with the first?
Objection relevance.
Grounds.
Sustained. Relevance 90611.
Any objections to warp speed? Because I think I want warp speed.
Is there any reason why the FBI can induct their own interrogation?
Who cares? He's not the
Cause for
FBI.
speculation.
Sustained.
1.5 or 2x. I'm going to 175. And yet it's still a
If you knew at that time that you and your partner would be conducting the second interrogation,
hey, this is better.
why did the FBI need to be present?
Objection relevance.
Grounds.
Ask and answer. Next question.
Answer.
It's the same.
You said ask and answer.
You've asked why the FBI was there multiple times. Your 90611 is one up.
Good job, Judge. Somehow I feel compelled to speak faster when it's on warp speed.
Is it standard procedure for other law enforcement to watch interrogations from another location?
Objection relevance.
Grounds.
Overruled. Give me answer.
Yes.
I wouldn't say it's
Depending
standard,
on the
but this
case.
wasn't also a standard incident.
So the magnitude of the incident is what prompted the change?
That's right.
Yeah, you
Do you
killed a
recall
lot
who
of
made that
people.
determination?
Objection calls for speculation relevance.
Yes, do you know? So overruled. The witness may answer.
So I'm sorry, just so I understand the question correctly. Why the FBI is the question why they'd be there at all?
No, that wasn't the question.
What is it again?
The question was pertaining to standard procedures.
Okay.
And I believe the question was,
You asked who made the determination to allow for other agencies to observe the
Right.
interview or interrogation.
thank you, Your Honor.
You're welcome.
I don't know exactly. I only know that the FBI became involved due to the terrorist concern, so that's why they were there.
My question wasn't,
He
Sure,
says
yeah, it was
that
law
that's
enforcement in general.
that's all he knew. He doesn't know who authorized it.
just to get more clarity, the question was,
He
did you know
said
who made the
he
determination
doesn't
for other law
know.
enforcement?
He
to watch
said
the
he doesn't know.
No.
Were you at any time aware that there would be other law enforcement watching the second interrogation?
Yes, he knew the
I knew the FBI
FBI
was
was
coming back,
there.
yes.
Did you know if there would be any other law enforcement outside of the FBI, like from your agency or anything like that? Were you aware that they would be watching as well?
Objection relevance.
Grounds.
Overruled. The witness may answer.
Not that I knew of.
It's of no consequence.
But you do recall other law enforcement outside of the FBI being present?
Yeah, so we had an officer based on you being in our custody that had to stay in the room with you, their jail area for the night. I don't know how much of the interview that officer was or was not present for from another location.
Do you recall leaving out of the interrogation room during the second interrogation?
Yes,
And at that time, did you speak with any other law enforcement?
FBI.
And do you recall what those conversations were about?
Not specifically, no.
Do you recall if there was directives given by the FBI?
Objection hearsay.
Grounds.
Oh, yes, do you know? Not what they were. You may answer.
I don't recall if they gave directives.
It's all a conspiracy. FBI
recall,
conspiracy.
Your partner stepping out of the interrogation room at any time?
Yes,
Do you know if they spoke with FBI at that time?
If my partner did?
Yes.
I don't know.
How would he? He would still be in the
At
interrogation
any time
room.
during the second interrogation, did the FBI leave?
Not that I know of.
So to your recollection, they were there the whole time.
I believe so, yes.
He was interrogating you. He wasn't babysitting the FBI agents.
And I want to go back to the phone for one quick second. You made a reference to the kind of code on the phone. Do you recall what that was? In reference to the phones that you were intending to access.
Huh?
You're talking about, there were two, any one phone specific? You're talking about the iPhone?
Yeah, the iPhone. I'm sorry.
Yes, you gave a pattern code.
A 7.
And what about the other phone?
No code was ever provided that I recall.
Why would the moon rover be at a crime scene? His
And do
questions
you recall that those two phones were
are
placed in
so
evidence?
stupid.
Yes, they would have been.
And did you place them in evidence?
I did not.
Do you recall whom?
I do not.
During your investigation, what? Let me back up on 1 second. You made reference to the suspect being involved. During that initial information that you received, did you receive information that there were multiple suspects at any time?
We're talking about the parade incident at this point, yes, no?
The parade incident, yes.
Initially, yes. So, and I've covered this in prior testimony as well. It was very chaotic early on in it. There were reports of possible multiple
It's
suspects.
almost like they didn't know what was going on until they narrowed down what was going on. You have to filter out the noise in an investigation. This had a lot of noise. You might say it had static.
I have some, I would think I could get done in 10 minutes.
Right, I'm just gonna let Roger stand for a minute.
I am absolutely shocked that he finished the cross today. I'm shocked. I really am. I mean, but then, like I said, he was either going to take his standard amount of pointless cross-examination, or he was
Exhibit
going to
174,
take
which is previously been
his
entered
standard
into evidence.
3
Do you recognize this
times
form?
the prosecution's time.
Overrule the witness may answer. It's been testified to previously.
Yes, I do.
Ah, the Miranda
Sir, if you
form.
talk to the same person 3 different times while they're in custody, do you have to fill out a separate form each time you talk to them?
Objection.
Overrule the witness may answer.
3 times.
Yes.
Would you have to fill out that top portion of the form each time?
Yes.
That's all I need for that exhibit. When we talk about, do you recall Mr. Brooks' questioning of you with regard to the recording made by your cell phone at Waukesha Memorial Hospital during the first meeting with the defendant?
Objection. I'll simply caught that night.
Voted overrule the witness may answer.
Yes, I recall.
Are you familiar with the term excited utterance?
Yes, I am.
Hey, that's a
Overrule
rule of
the witness may
evidence.
answer.
What is that?
It's when an individual, whether it be Mr. Brooks or any individual, begins making statements on their own accord in not response to a question.
Meaning,
Typically,
it's admissible.
Utterance may reference why they're in custody in a situation that you're either questioning them about or preparing to question them about.
Is it important to capture those types of utterances on tape? Or
Yeah.
recording?
Objection speculative.
Overrule the witness may answer.
Yes, it is.
And that's
Would that
why
be a reason
you
to continue
record,
recording after an interview's been ended?
even if
Overrule the
you're
witness may
not
answer. Redirect.
Yes, it
interviewing.
would.
With regard to the 2 phones, you indicated that someone else located the phones in the defendant's car. Is that correct?
Yes.
And in order to access the contents of a phone, if it's passcode protected, do you need the passcode to enter it?
Objection. Leading.
Overrule the witness may answer.
It makes it easiest. They can, the men that do that, the men and women that do that do have ways around it, but
You
it
can
makes it much more
jailbreak
difficult.
it, but
And would
the
it be fair to
passcode's
say
the
that there's
easiest.
not all software can enter into all phones without the passcode?
Objection speculative.
Sustained as the foundation.
Have you had experience in your position as a detective seizing phones off of defendants?
Yes.
And have you had opportunities to turn those phones over to your forensic unit to have them analyzed?
Yes.
When you don't have a passcode or a swipe pattern, have you received those phones back with information that they were unable to be accessed?
Objection. Asked the form of that already and answered.
Overrule the witness may answer.
Yes, I have.
So if you're not provided a code or you're provided an incorrect code, there's a possibility, or are you definitely getting into that phone?
Objection speculative.
Overrule.
No, there is certainly a possibility that we would not be able to access the content.
You had talked about on cross-examination, your reports that you dictate over a phone line. Do you recall that?
Yes,
Those you testified were based upon your recollection.
correct.
Do you take notes during interviews?
Objection, speculative.
Overruled.
Speculative?
Yes, I do.
you
Do
take
you use those notes
notes?
at all when dictating your report?
Yes, I do.
The defendant asked you about
Whether
multiple
or not
suspects.
he
Do you have
takes
any information
notes
about
is
multiple suspects? Do you recall that line of
speculative?
questioning?
Yes, I do.
Did the defendant ever tell you that there was anyone in that car other than him driving it and possibly Erica Patterson?
Objection, leading the witness.
Overruled. The witness may answer.
No, he did not.
And finally, you've been a law enforcement officer in Waukesha County for approximately 18 years. Is that correct?
Yes.
Who makes the charging decision when deciding what charges get issued in a criminal case?
Objection, leading.
Overruled. The witness may answer.
The DA?
The prosecuting attorney at the Waukesha County District Attorney's Office.
You don't decide on the charges?
No,
Objection, relevancy.
It's overruled.
It's relevant because you keep
we can forward
bringing
what we believe
up
is appropriate, but we don't ultimately make the
loitering
decision.
charges.
So when Mr. Brooks asked you, what am I being charged with? Did you have any ability to tell him that?
Objection, I don't consent to being called that name.
Who cares?
Noted. Overruled. You may answer the question.
No, ma'am, not with 100% certainty, no.
Nothing further, thank you.
All right. Thank you. Detective, you may sit down. Ladies and
That was
gentlemen of the jury, as
brutal.
Detective Carpenter stepping off, I will read the instruction that I've read to you every day, but it's important that you hear it again. Do not begin your deliberations and discussion of the case until all the evidence is presented and I have instructed you on the law. Do not discuss this case among yourselves or with anyone else until your final deliberations in the jury room. This order is not limited to face-to-face conversations. It also extends to all forms of electronic communications. Do not use any electronic devices such as a mobile phone or computer, text or instant messaging or social networking sites to
I
send
bet
or receive
he's
any
doing his
information about this
performance
case or your
Bible
experience as a juror.
reading
If you come in contact with the parties,
before the
lawyers, interpreters, or
stream
witnesses,
is
do not
cut.
speak with them. For their part, the parties, lawyers, interpreters, and witnesses will not contact or speak with the jurors. Do not listen to any conversation about this case. Do not research any information that you personally think might be helpful to you in understanding the issues presented. Do not investigate this case on your own or visit the scene, either in person or by any electronic means. Do not read any newspaper reports or listen to any news reports on radio, television, over the internet, or any other electronic application or tool about this trial. Do not consult dictionaries, computers, electronic applications, social media, the internet, or other reference materials for additional information. Do not seek information regarding the public records of any party or witness in this case. Any information you obtain outside the courtroom could be misleading, inaccurate, or incomplete. Relying on this information is unfair because the parties would not have the opportunity to refute, explain, or correct it. Do not communicate with anyone about this trial or your experience as a juror while you are serving on this jury.
If
Do
I
not use a
play it
computer,
on
cell phone, or other electronic device, including personal
1
wearable electronics
3/4
applications or tools with
speed.
communication capabilities to share any information about this case. For example, do not communicate by telephone, blog post, email, text message, instant message, social media post, or in any other way on or off the computer. Do not permit anyone to communicate with you about this matter, either in person, electronically, or by any other means. If anyone does so, despite you telling them not to, you should report that to me. I appreciate that it is tempting when you go home in the evening to discuss this case with another member of your household, but you may not do so. This case must be decided by you, the jurors, based on the evidence presented in the courtroom. People not serving on this jury have not heard the evidence, and it is improper for them to influence your deliberations and decision in this case. After the trial is completed, you are free to communicate with anyone in any manner. These rules are intended to assure that jurors remain impartial throughout the trial. If any juror has reason to believe that another juror has violated these rules, you should report that to me. If jurors do not comply with these rules, it could result in a new trial involving additional time and significant expense to the parties and the taxpayers. You are to decide the case solely on the evidence offered and received at trial. And while I still have you here, I neglected to tell you one thing about an exhibit that was received. Exhibit 81 has been received by the court. With that, you are excused. Thank you, everyone. 82.
Oh,
Boy, it's been a long day, but okay. 82. Thank you. Right, 82. At 81 in the brain.
well. Any arguments from Brooks on the way out before the record's cut? Are they going to do housekeeping as far as tomorrow's schedule?
Thank you, everyone. They are recessed. We'll see everyone at 8:30 tomorrow morning.
Oh, I'm surprised. She cut it. All righty then. So that was brutal. I don't see how any of that impacted the detective's credibility one bit. It was frankly a terrible cross-examination. It pissed off the jury, put me to sleep. It just, as I've said, cross-examination. Bring in good facts for you. He didn't do it. Bring in contradictory statements. He didn't do it. Bring in bias from the witness. Didn't do it. bring in unreliability of the witness. Didn't do it. That was 2 hours and 51 minutes wasted. And when I say 2 hours and 51 minutes, it's really 3 hours because we did some of it on almost double speed. That was ridiculous. So, with that, thanks for joining me this afternoon. Like and subscribe on your way out. If you didn't on your way in. I'll be back bright and early tomorrow. It's going to be a short day because court's taking a field trip. But I think we've still got, at the very least, the morning session to keep us entertained. So, with that, good night. Thanks for joining me. Have a good one.